Public.
May permit to mention, my lord. It's a fresh admission tender matter, my lord. I prefer tomorrow, my lord.
Slip, please.
Oblige. Oblige.
Place admission.
Give your slip.
Place admission.
This matter relating to nursing college matter, your lordship, and this matter was listed before your lordship on 20th August 2024. The counter had not come to your record. Therefore, lordship, after hearing both the sides, adjourned this matter specifically on 27th of
Give your slip, give your slip.
that has been wrong. The inadvertently typed down as 27th.
Yes, yesterday you were mentioning. So have you filed for correction or anything?
Give your slip, we will see.
That order, your lordship's order, I have.
Please give your slip, we will see.
That has gone to 27th September. Therefore, my respectful submission to lordship 4/9/2024 today.
Can we not commit mistakes?
All the matters
We have a duty to correct ourselves also. We'll do that. It will be taken up on Monday, mister. It will be listed on Monday.
Yes, your lordship 4/9/2024.
All right.
4/9 what? 4/9 what?
All the matter, nursing matter, yesterday, which has been detailed.
So 4/9 is
All right.
fine.
4/9 it will come.
4/9, 4.
I'm permitted to make mention, my lord. One phrase admission, academic matter, my lord. The present petition,
Give your slip.
my lord, counseling already started, my lord. Can this matter taken?
Your matter is listed.
No, my lord.
Then
Yes,
have you
sir.
filed any mention slip?
Today, my lord.
Where is
Today
your
I'm-
mention memo? Have you written? What all
Yes,
you are saying, have you
yes,
written
yes,
there?
Yes, my lord.
We will see. Give your slip.
Oblige. Pardon to make a mention, my lords.
Please
My
give
lords,
your.
we are the intervener in this present case. My lord, withdrawal memo has been filed by the petitioner. My lord, the bench may be, appropriate bench may be constituted to.
Withdrawal.
Petitioner has filed a withdrawal. You don't want the withdrawal or what?
No, my,
Oh, but withdrawal, why should it be appropriate bench? It can be any bench.
my lord,
Signed bench.
it was not, the order was not signed by Honorable Justice B.R. Sarangi, and the bench was of Honorable Justice B.R. Sarangi and Justice G. Satpathy.
Okay. So order was not signed.
Yes, my lord. So,
Give your slip. We will see.
Have you mentioned all that in your memo?
yes, my lord.
Item number 1.
Please, your lordship. It's a matter related to Sisu Wall.
Yes, item number 1, your lordship will look at your lordship previous order. Lordship directed me to file an affidavit with regard to fire safety and lordship that building it. Because of this, unrest of the doctors, so the superintendent had to go through. He has prayed for only week's time to file that affidavit. You are requested to.
Has it been called off?
Yes, it has been now called.
off.
What is the last order?
Actually, last August.
Administrative
1/8.
proceeding. Did not
August. 1/8/2020. Last August.
Mr. L. Samantha, additional government advocate, appearing on behalf of the state shall require to inform this court as regards grant of fire safety certificate by the competent authority in respect of the G+6 newly constructed building in Sardar Vallabhbhai Postgraduate Institute of Pediatrics, Sisuwan, Cuttack. We also expect him to inform us as to by what time the G6 newly constructed building has been.
When was this building constructed?
constructed?
When was this building constructed?
No, building has been almost completed now. It was it had started about, I think, 3 years back. And now it is complete almost in all respect. I think we are on the way. If you are seeing adjacent to this building, it's almost complete. Only fittings and other things will be there, and thereafter fire certificate shall be given after inspection.
The Standard Senior may not be aware of the fact in 2021 November, when the Advocates Committee visited the Sisuwan in presence of engineers and the authority who take construction of the building, they assured that it will be completed by March 2022. While the NFL submitted the 3 years it is started, not like that. That
No,
will be
no.
completed by 2022 March.
Okay, so if it
Now-
has not been completed, is the construction illegal?
No.
Then?
When submitted, the construction started 3 years back. Completed by 3 years back.
All right, as requested on behalf of requested by Mr. AGA, Mr. So-and-so, learned AGA, to list this matter on 2 weeks. Thursday, retaining its position, comma, so as to enable him to comply with the order dated 1/8/2000.
First ticket.
1st August. 1st August. Order dated 1st August.
First, yes, 1/8. We have said 1/8/2020.
May I pray, my lord? Last chance may be given, only we get 2 years. When
Let us-
people have
this
to
is
suffer
PIL.
a lot, my lord.
This is PIL. Everyone's interest is involved
My
in such matters.
Small
Your,
my lord, small kids are suffering,
we will see.
my lord.
We will not allow them to suffer.
Oblige me.
As per C
Item number-
concern, that report to attendant the patient, not to the administrative work. Administrative work is going on.
The doctors are still on strike.
No,
No. Doctors of nurse, PG doctor, here also it's a PG course nurse. I
Yes.
don't know nurse, why my friend is we entered all this. Here it's a PG institute. And all the PG students were in charge, were on strike nurse.
All right. Yes.
Item number 2.
patient take your portion.
All right.
All right.
Oh, this will come on Monday.
Not dictating the order.
Yes.
Only one clarification on the last date of hearing, my lord wanted that, but I could not point out. My lord, may kindly turn to page 61. So my lords wanted whether non-submission of these two documents entails rejection or not.
Yes. this is
Well,
for
that
you.
is a clause, that is one clause at page 55.
Page 55.
Yes, clause 6.11.2.
Just one moment, please.
Is 55 bottom, 6.11.2. At
Right.
any point of time, the tender inviting authority reserves the right to reject the bid if the bidder fails to fulfill the terms and conditions of the bid document, including technical specification. Furnishing of relevant documents and information in the required format of the tender and demonstration were required to the satisfaction.
55 clause, rejection of bid, 611.
Yes,
Yeah.
I am placing 6.11.2.
Internal page 24 of that document in the bottom it is.
Running page 50.
— 6.112.
Yes, 11.2. It provides at any point of time, the tender inviting authority reserve the right to reject the bid if the bidder fails to fulfill the terms and conditions of the bid document, including technical specification.
This you have not pointed out in your counter.
Yes.
Yes, I have pointed out in my counter also.
The last occasion, my lord wanted this clause, but I could not point out that. And this technical specification starts from at page 86. And the documents which the petitioner has not submitted, that is available at page 89, clause 7 and 11.
All right.
I'm appealing for the petitioner, Your Lordship. I'll just point out the clause which my learned senior has showed. It is also subject to that particular clause that minor infirmities cannot be cured. I'll just submit that on, Your Lordship.
Which
That's
clause?
6.18.4 at page 62, Your Lordship.
6 point?
18.4. page 62, Your Lordship. I'll leave it to Your Lordship's wisdom.
6.18.
18.4, Your Lordship.
18.4. So
That is
two
what-
parts, substantial error and minor error.
Minor infirmities.
These are the vital documents, quality certificates.
They have, it says that it has to be submitted, and then if there is any minor error, it can be cured. But not that without submission, it can be later on, Lord, added to the bid.
This 6.18.4, I have clarified in my counter that it is of two parts and the non-submission of the
I
measure.
think paragraph 11.
Yes.
Yes.
Lord.
Submitted more.
Every day one note we are getting.
Information form. I have stated everything in my counter of the opposite, but not 4 and 6.
If note is shorter than the counter, then you can give.
So one page note just
Only one
pointing
page.
out the.
Yes,
Whatever the
yes.
budget.
That.
But
so that
today,
it-
today.
We had submitted
By
our,
tomorrow.
By tomorrow.
Tomorrow morning, that's-
we had submitted our written note.
Yes, yes.
yesterday.
Very short and lacks material particulars.
Your Lordship.
Okay.
Grateful.
of life.
Item number 3.
This for your lordship's order in that court of wards matter. Your lordship, remember, I've given that note on the legal issues.
Pion ki achan. Actor rahigala.
That the
Pion.
original authority as well as the appellate authority lacks jurisdiction. That's your, and your lordships, without entering the merits, had decided that have given. Not the- Good. It's in the some. I had given copies and some flat, and I can give additional copies also. Because, do you read that copy? Yeah, sign for it. Sign for it. Okay. It additional notes. Additional notes. Additional notes on the legal issues only. Because that notes, first note was on merits, which your lordships would not like to get into.
Do you have a file?
Yeah, I had given them, I have got copies. Extra copies I can give. I
You have a copy?
Yes,
Just for the purpose of,
yes, sir. Okay,
yes, it is there.
yes.
What are the provisions?
Yes. The provisions could be, which could be relevant, my lord, is to add with definitions. Definitions. A, 4A, the court means the court of wards. Lords again. Court means the court of wards, 4A. Then the lordship is 5. The court, the revenue commissioner shall be the court of wards for the areas for this act extends, revenue commissioner. That's 5A. Then your lordship says,
5-1.
oh, sorry, I'm sorry. 5-1, revenue commissioner shall be the court of wards for the areas to which this act extends. Then the lordship says 7. The court may exercise all or any of the powers conferred on it by this act through the collector of the district, within the limits of which any part of property is situated, or through any other person whom it any time appoint their behalf, and may confer any of the powers and person withdraw any powers are enforced. The collector of the district, if you also remember. Then 9, my lord, all orders or proceedings of the collector or other persons as aforesaid under this act shall be subject to the supervision and control of the court. Court always means in this case is a court of wards. The court may things may revise, modify, etc.
Mr. Paddy,
Sir,
revenue commissioner will be who?
revenue commissioner will be the revenue divisional commissioner under some classes.
Revenue divisional commissioner.
Because he is an authority higher than the collector and he is the only authority available. Then your lordship sees 26. 26, my lord.
Yes.
26, my lord, the court may appoint managers for the property and guardians for the persons in the ward. In the instant case, my lord, the tehsildar was acted original could be considered as the manager of the property. And 22 also could be slightly relevant, my lord. When the court has assumed the superintendence of the property of a ward, the collector notification, the court, the collector of the district, his situation shall take possession. These are matters not in dispute that the property is under their possession and the tehsildar was acting as the manager. Then your lordship says 34. No? Is the delivery part, which is to consider. Now, what your lordships are concerned is the direction, the delivery of the property from the court of wards to the person who is entitled to receive it. 34, my lord. The court may order any past or present manager or guardian or present officer deliver of his accounts or any property which may be in his possession within such time as is fixed. Court can direct its delivery. 34. Then 58 is at adjudication, which is to be done by the on this context. They can refer it to civil court if they for their opinion. When any question arises as between two or more wards of such nature that an adjudication upon it by civil court is expedient. That's here they use the word civil court. Because otherwise they were using the word court as court of wards. Civil court is expedient. It shall be lawful for the court of wards acting through the collector of the district in which a case might have been stated for the opinion of the civil court with regard to such matter of the first schedule, etc. Then your lordship says, then the release shall be on 59. The court may, with the previous sanction of state government, in all cases where superintendent has been assumed in person, the order on 16 or 10 release from its superintendent the person or property of the ward or both. Now, question is, my lord, essentially, the property was under the court of wards. From court of wards, the tehsildar was the manager, and there was a direction of the High Court, which had that the appropriate authority, not the word used was appropriate. I quoted that portion of the High Court's order. Okay, actually. That High Court order, my lord, if you lordships, on earlier order of the High Court, my lord, would your lordships like to see they didn't direct any authority but the appropriate authority. Lordship sees at page 2 of my note I've quoted, that is available.
Yes.
Yes. The learned addition appearing Lordship get under the management court of wards. Your Lordship may just read 2 paragraphs which I've quoted. On behalf of OP number 11, a counter affidavit to the when I was 11, my lord, in that proceedings. As in file indicating therein that in title suit, etc., the rights of respective parties in respect to the land in question have already been determined. And there has been a final decree, and therefore the right of parties must be governed by the final decree in question. We need not consider the rival submission in this aspect as to who would be entitled to grant in question, whether the petitioner alone or other co-sharers, and whether petitioner and whether there is any decree of a competent civil court in respect to land in question, and whether the order of the Darbar mutual name of the Badrinath in respect to land in question and illegal, legal, and leave all these materials to be considered by the state authorities. Of course, when the court did not go into details of who is the authority. State authorities. State, in the meantime, have considered and request a petitioner. In fact, have called upon him to appear to get release of the grant in question in the miscellaneous. And additional standing on the appeal state also state they all decided to release the entire land which are under the management of court of wards in favor of the rightful claimant. In this view of the matter, we dispose of the writ application to the direction that the appropriate authorities to consider the petitioner's claim as well as that of opinion number 11, which I was, by giving them opportunity to produce relevant materials in support of their respective stands, and thereupon shall decide as to who or all of them are entitled to take over the management. He called upon to give an opportunity hearing in the period of 4 months, which never happened, my lord. Then your lordship says, what happened, my lord? The parties approached the collector for this purpose, which is at page 173. Parties approached the collector. Collector relegated it to the tehsildar, who decided. I mean, at that stage, probably parties were also not aware fully that he is not the competent authority, so all proceeded under the tehsildar. Then obviously, because the tehsildar has passed the order, the opinion number 4, who lost before the tehsildar, that directed that in view of the civil suit, it should be partitioned. He preferred an appeal for the additional district magistrate, who assumed authority on the general principle that I am the superior authority to the tehsildar and hence I can exercise appeal, and pass that impugned order, which is before your lordships. So now, my lord, parties have already approached. Direction of the High Court is there. Only that authority who decided from the inception possibly is, your lordships, is not authority to decide. So the matter.
Where is that order of the High Court?
Yes, sir. The order of the High Court, your lordship should get it at page 166 in the writ petition. I quoted only.
You have quoted relevant part.
I quoted, but I have the order itself in the writ is in the
Annexure
11.
Annexure 11.
Yes. That is there at page start from 169 and is 171 and 172 are the directions. Lordship knows, I mean, nobody can be blamed, including the parties also, in the sense everybody proceeded with a misconception probably that the tehsildar itself is the competent authority to decide, which is not, as your lordships have rightly seen it. Your lordship is the appropriate authority at page 172. Call upon the parties concerned, thereafter shall dispose of the matter.
Who had filed the writ petition?
Sir, I filed a
No,
writ.
you had not filed. You were responding.
No, I filed the writ petition.
Achha, you had
Because
filed.
the ADM reversed. I was the tehsildar directed in my
Petition
favor.
was filed by you.
Sir,
The writ petition was filed
filed by
you,
me.
not
Because-
this writ petition.
The earlier 8% was by him.
The earlier rate.
I was the opposite party there.
Therefore,
Yes, earlier was by him. Earlier was by him. OP number 4. And I was the OP number 11 there.
4 in the present case.
Present case.
Yes, is the OP number 4 in the present case.
Where there was direction that the competent.
Appropriate authorities shall decide. And the application to the collector to comply as per the direction of High Court was at page 173.
That was filed by.
It was,
By my claim.
I think I'm
That.
not sure about
he
whether
said
all
that
parties.
has been filed.
Probably he filed, but there are other signatures also. I'm not sure whether he alone filed or others have filed.
Sir, which document?
173.
So we can
Because that
take,
I say we, not me.
we can take facts from the order dated 25/6/1991.
Yes, it's. 2691 facts are common.
If it is not.
Facts are
Thereafter,
common.
Facts are,
Facts are
the only thing is as to whether after this order.
Right.
The issue, the matter was decided by competent authority under
Or
the act
not.
or not.
That
Yes,
is
yes,
the only that is the only point.
That is, according to you, the collector, Tahsildar
And
is
ADM are
collector
competent.
and ADM is appellate.
And the state counter is also the same. State also filed the counter affidavit stating that the Tahsildar is competent and the ADM is the competent. The source of
This type of.
source of submitting that. Already in 1947, this is all our small state, native states.
No, that is not the question. The question is who decided.
No, right, I am saying that.
Right.
Therefore, the government of India brought a Foreign Jurisdiction Act in 1947. Foreign Jurisdiction Act. All those states are foreign states on the date of 15th August 1947 because there was no merger agreement with the states. Those merger agreement was subsequent to 15th August 1947. After the merger agreement, the small states became a part of British India or Free India. The central government directed the state authorities.
But why should we go into that history?
No, it is necessary for this act, this thing. The government of Orissa brought a legislation called Administration of Orissa State Order 1948. There, it has decided who are the authority to decide which matters. That there is a column under Rule 6. There is a column insofar as revenue jurisdiction is concerned. Revenue jurisdiction in which states? States has been mentioned. Gangpur state. Here the princely state is the Gangpur state. My father was a Zamidar under that state. Therefore, I am governed by that Gangpur state. Court of Words is one of the act which cover under the Administration of Orissa State Order 1948. And there, it provides the original authority, the subdivisional officer or any other officer fixed by the collector. The collector fixed the Tahsildar as the authority. And appellate forum, collector or the additional district magistrate.
No, this submission you are making for the first time.
Last.
This submission which you are making today, you are making this for the first time.
No.
So is this your submission? Just a minute.
Right.
Is this your submission that courts of Orissa Courts of Ward Act 1947 has no application?
Sir, 100% application.
If
I
it
don't
has
say
the application, then we will have to read the collector as defined under the act, the court as defined under the act.
under the act, the court means the RDC is the final authority under the act who can release after taking the permission from the government of Odisha. And what ADM says here, ADM directed the Tahsildar, you place this matter before the RDC with the Court of Words to take permission, and the RDC is competent either to release or to decide in otherwise. Here it has been decided by Tahsildar. Suppose both the authorities are wrong, it will be decided by the court. My learned friend submitted the court. I completely bowed on my lord. The court is the RDC. RDC will take a call taking into consideration all these materials, whether it will be released in favor of X or Y, or
So let us see you, which provision, this submission, in fact, this was not made, this submission was not made on.
no, my lord, that is the order, that is the appellate order.
May I just tell
That is
your
the
lordship-
appellate
may
order
I just
which
tell
has been
your
impugned.
lordships?
Huh?
May-
That is the appellate order which has been impugned.
No, that appellate order. Yes, see, you are referring to certain provisions
My lord,
under the orders issued in 1948.
my lord.
Issued in 1948. This submission you had not made on the last date.
My lord, on the other day, I have submitted and your lordship called
The
for that
submission was
volume
made.
one.
Say yes, we might have forgotten.
Yes, my lord, in fact, I
I
have.
just take a one
On the other day, my lord put a
Yeah.
question me under which serial number the court of words has been mentioned.
All
I
right.
could not point it
Yeah.
out. There.
All right. May I take a minute of your lordships? There are two aspects of this case, my lord. One is on merits, one is on jurisdiction.
No, we will not go into.
So if your lordships go to, what is saying that, what he's submitting essentially is, lordship may not go to merits, but the ADM order may stand referring it to the collector. But either if it stands on merits or doesn't stand on merits, yeah, without jurisdiction. If it has no jurisdiction on the ground that the Tehsildar itself had no jurisdiction, the ADM has no jurisdiction, things are on without only on the issue of jurisdiction. If it is on merits, then the question has to be decided whether the Tehsildar had decided rightly or the ADM has decided rightly. What he's saying, Lord, essentially,
No, he is saying something else. What he is saying that Tahsildar was not the final authority to decide. It is the collector under the Court of Wards Act who has to take a decision.
that
So
decision,
Tahsildar determined, which he had a right under the 1948 orders.
Right.
And then the collector had the additional collector or the district magistrate has the jurisdiction to hear the appeal. He decided the appeal. Now, the final decision, according to him, is to be taken by the
RDC,
court under
Yes,
the
Lord.
court of words.
Lord,
Court of
if-
Wards
what I'm
Act. This is what he submitted.
Yes, but may I humbly submit, Lord, if the final decision, Lord, what the ADM, if your lordship, Lord, it is taking from here, some part of here and some part of there. That's not, Lord, all. That you can't take part of it, that, Lord, if the ADM order is to be considered on merits, it's not a question that it's the preliminary order. The ADM's order, your lordship sees, the ADM order, the impugn order. Lordship says, what is saying that, if Lordship is referring to page 210, section 59 of the Court of Order. If Lordship get at page 210.
210 of
Yes, of the brief.
Brief.
Lordship says, what is said 210, Lord, just before the para is the order of the learned Tehsildar, Mitrapur is liable to be set aside. Yes.
The section sentence starts from section 59 of the
No,
court
let
of
me
words.
press. I'm just pressing. The section 59, before that I said,
Yes.
section 59 of the Court of Act prescribes that court may, with the previous sanction of the provisional government in all cases where superintendent has been assumed order in section 16, 17, and 10, release from its superintendent the person or property or a ward, etc. In section 62, release from superintendent, hence release of the estate will require sanction of the provincial government. The Tehsildar is now the manager of Court of Order, let him take the sanction. What is saying? ADM order is final. ADM order may not be tinkered with. Now the ADM order can be worked out like any other order. But ADM order is taken to be now the order of a Court of Wards. And what the Court of Wards would have done under 59 is to take the approval of the state government, let it take the approval of the state government. My lord, it is not possible, my lord, to take it that. Either, my lord, if a lordship decides, yes, merits, but in fact, I stand a very good case on merits because it's
merits.
because it is conclusively decided by a civil court.
Merits we can go into only after we reach a conclusion
That the jurisdiction was
they
there.
had the jurisdiction.
Yes. If the jurisdiction was, what he is saying that, what essentially is saying that Tehsildar had the jurisdiction and ADM had the jurisdiction. What essentially is submitting, my lord, that the Tehsildar also had jurisdiction and the ADM had jurisdiction. Obviously, my lord, standing for my client, I will only say that ADM had no jurisdiction. But knowing the law, my lord, now being enlightened by your lordships, I know that the Tehsildar also had no jurisdiction. So now, my lord, if your lordships come to a conclusion that the Tehsildar and had no jurisdiction and the appeal has no jurisdiction automatically. Because if the Tehsil had no jurisdiction, question of appeal doesn't arise.
So let us again see that provision, that 1948 orders which you are referring to.
Volume 1 Local Act.
I know. It had. Yeah, it will only pass. That's
Volume 1 Local Act, Administration of Odisha State Order, page 64 रे बोले.
Yes.
Clause 4, law to be applied. This is the Administration of Odisha State Order 1948. Clause 4, law to be applied. The enactment specified in the first column of the second schedule hereto annexed shall, so far as circumstances admits and subject to any amendment to which the enactment are for the time being generally subject in the territories to which may extend, apply to all Odisha states and any provision of any law in force, whether substantive or procedural, and whether based on custom and usage or statute in any of the Odisha states which is repugnant to any of the provision of any of the said enactment shall be extended, shall to the extent of the repugnancy ceases to have effect from the date of commencement of this order. Your Lordship, I will take to Schedule 1. In Schedule 1, at page 72, this is within the state of Gangpur. Gangpur state has been mentioned at serial number 2. At page 72, Schedule 1, the whole state of Gangpur, Sundargarh. This is within this Gangpur, Sundargarh. The property situated within the state of Gangpur, Sundargarh.
So why are you referring to this provision?
I am referring the Court of Words is part of Schedule 1, column 2. That is at page 94. Odisha Court of Words Act 1947.
So what does it mean?
That means the determination shall be made as per the provisions of Administration of Odisha State Order 1948.
And not in accordance with the Odisha Court of Orissa Act 1947.
47.
So this order overrules repeals this provision, right?
Orders will not.
Can this order override the provisions of the Court of Orissa Act? Why are you referring to this?
This is not overriding.
Then?
In addition to the provisions,
Where is
there
the
is
question
no
of-
specific provision under the Court of Words Act.
There is a specific provision under the Court of Orissa Act.
Here is the question
No.
arises, who is the authority to
Who is the authority is clear from the Court of Orissa Act.
under the Court of Words Act? It is the RDC, which is means the court.
It is entirely different. Purpose is entirely different. What's the purpose of the Courts of What Act is entirely different.
The section 6 of that order provides the revenue jurisdiction. The revenue jurisdiction under clause B, 6B and 6C. 6B
See,
provides,
this is entirely different thing. This order is entirely different. It cannot govern the provisions of the Odisha Court of Wards Act. Just refers to that this order shall apply to these provisions. That's all.
these provisions will be applicable in respect of all the acts which has been appended under Schedule 2. In the Schedule 2, one of such act is Court of Wards Act 1947.
then-
That is only my submission.
Then
Then
what is the consequence of this?
consequence of this is the Tahsildar has passed the order and the appellate authority is the ADM.
No,
Under
where
six-
does it say the Tehsildar has the jurisdiction?
No, your 6 revenue jurisdiction, your
Yes.
lordship may kindly have a glance to B.
Yes.
Every subdivisional magistrate and any other officer specially empowered by the collector shall within the local limit exercise the jurisdiction of on all revenue matters.
Why
under
are
the-
you making? Just see what is the provision. You are relying on this. Notwithstanding anything contained in proviso to so and so,
Right,
this order, Commissioner shall be the highest revenue authority
right.
in all Odisha estates and shall exercise all original appellate or original powers which were exercised by the ruler of the estate.
Right, commissioner is the
different-
head.
It's for a different purpose.
Then here the purpose is the commissioner under the
Purpose
Court
is
of
not
Wards
the
Act.
commissioner. Commissioner is an authority.
Commissioner refers to the RDC. And under the Court of Wards Act also refers to the RDC. My entire submission before lordship is the authority under the Court of Wards is the RDC. He will take a final decision whether the property will be released to X or Y. If it is in his opinion, it is expedient to get an opinion from the court, he may refer to the court for its opinion. I don't disagree with my learned friend by saying the RDC is not the competent authority. I quite agree with the fact that the RDC is the competent authority to take a final call.
Yes.
And that is the appellate court order. And while
Do you have
disposing
this
of
act? Do you have this Act, Foreign Jurisdiction Act 1947?
yes, I have. I have brought only one copy.
So according to you, this act will apply. Foreign Jurisdiction Act 1947.
Now, as that in the front page, your lordship, notification number 2A dated 21st January 48 in exercise of the power conferred by section 4 of the Foreign Jurisdiction Act 1947, read with notification number 1 of the Government of India in the Ministry of State, Government of Odisha, are pleased to make the following order for the effective exercise of foreign jurisdiction in Odisha states namely, and all those small states which subsequently merged with the state of Odisha, Dominion of India.
Just a minute, just a minute.
And there are judgment by this honorable court regarding the application of administration of Odisha State Order 1948 to the state of Gangpur. And in respect of not,
To what
in
effect?
respect, Madam, I beg
To
pardon.
what
Judge already.
effect? Is there any decision
Madam.
of any court
Madam.
that the dispute can be determined by Tahsildar or the additional collector?
I have. Regarding,
Not be.
regarding the court of words, I could not get any.
There cannot be. So
And,
whether the,
I could not, I have a librarian of the Board of Revenue Library. He has expired 10-15 days back, there is some circulars issued by the government of Odisha. I could not
Maybe.
trace out to those circulars.
Let us try on the basis of what is there before us.
My lord.
The original petitioner is alive. The petitioner who had filed the
Writ petition.
Writ
Yes,
petition
yes, my
is
client is
alive.
alive. His father was the corpusdar. My lord, very facts only. Since
Yeah,
last 14 generation, it is in the record. I am not
You get married.
stating anything else. Since last 14 generations, the eldest son succeeded the Gadi, became the Jamidars.
But there is a title, so
Yes,
you tell that.
yes, I will tell you. In the year 1940,
The respondent number 4 had approached this court by filing a writ petition giving rise to OJC number 1460 of 1995 with seeking direction to the state authorities to release Atibari alias Injir Estate, said to be a Kharpos grant, Kharpos single in favor of his predecessor in interest by the Darbar. Stop. He asserted that the grant in question concerning 64 villages had been made in favor of his common ancestor much prior to 1940. Stop. The respondent number 4 referring to the genealogical table as relied on in the said writ application, the respondent number 4 asserted that on account of mismanagement committed by the grantees, Court of Wards. Please take your seat, Mr.
Public.
Court of Wards took management in respect of 60 villages and sometimes in the year 1940 and thereafter on attaining majority, applications having been filed to get release of the management of those villages in question, there was total inaction on the part of the state authorities. Stop. In the aforesaid background, the petitioner approached this court by filing the aforesaid writ application seeking direction to release management of 60 villages to which the respondent number 4 was entitled to. Stop. The said writ application was disposed of by an order dated
25/6/1991 by with following directions and observation. In this view of the matter, page 171. It is, why,
Only your lordship dictated the petitioner filed the earlier writ application.
that will correct.
Yes.
That will correct. This one number 4. We have taken the facts as noted above from this court's order dated 25/6/1991 above noted facts. Oh, stop. From the said order, it further transpires that in course of this court, while passing the said order dated this court, while passing the order dated 25/6/1991, did not entered into the rival submissions advanced on behalf of the contesting parties, including the writ petitioner.
Writ petitioner who has OP number 11.
Writ petitioner bracketed OP number 11 in OJC number so and so. As to who would be entitled to the grant in question, that is whether the petitioner alone, respondent number 4 alone, or other co-sharers, and whether there was at all any decree of a competent civil court in respect of land in question, and whether the order of the Darbar mutating the name of, who is Badrinarayan?
My father.
Predecessor.
The OP number 4's father.
Father of respondent number 4 in respect of the land in question. So stop. The court left all these disputes to be considered by the state authorities. So stop. Next.
it is noteworthy, comma, as is evident from the said order of this court dated so and so, that the state of Odisha had also conceded to the request of respondent number 4 to get a release of grant in question by asking him to appear before the appropriate authority. Stop. It was in that background that this court disposed of the writ petition with the observation and direction as has been quoted herein above. Stop. In the light of the observation and direction made by this court in the order dated 25/6 to 1991, respondent number 4 approached Tahsildar.
It would be whether respond parties approach, because there is a
Parties, all of them.
parties approached
The collector.
the collector,
Parties approached the
Collector.
collector.
page 173.
Page 170.
3, sir. In the record. Annex 12.
No, this is not. What?
This is my,
This is not the application.
my-
The Tahsildar initiated a suo motu proceeding and issued notice to the parties.
Just a minute. Let us be clear on the facts.
Yes, ma'am. This is not that document.
Somoto. Could be, sir. I am not very sure about that. Could be Somoto. The Tahsildar took up your consent. That is page that 176.
Where is that?
176. Well, parties appear before the Tahsildar. You will also see the first paragraph. 176.
At page 178, the case act.
What is the date of the order which you mentioned?
Finally, it's
20.
30th of July 1993.
30th July 93.
19.
93.
This court's order.
No.
I'm
To
talking-
Tahsildar, sir.
Yes.
No, what is the date? I'm just forgetting.
Court's order.
5/6/1991.
High Court's order is 25/6/91. High Court's order is 25/6/91. Tahsildar.
It transpires
Yes.
that in the light of this court's observation and direction, case number 1 of 1991 was registered in the court of
91.
Tahsildar Birmitrapur. Stop. The petitioner and respondent number, opposite party number 4. Opposite party, you are opposite party number 4 here.
Respondent number 4 or opposite party?
Here opposite party number 4 appeared before Tahsildar the parties submitted documentary evidence in support of their respective claims. So stop. The Tahsildar disposed of the said miscellaneous case number 1. Miscellaneous case number 1 of 1991 with by an order dated 37/19/93, which reads as under.
Page 190.
190.
The conclusion of the Tehsildar is at 190.
Operative portion of which reads as under 190.
So 190. Yes, 190. You'll get prosecuted last time.
No, we got it.
In such.
Basing on above discussion. Stop. The Tahsildar mentioned in his order dated 37/19/93 that where is the appeal? Some observation, detailed findings.
Page 190 is Tehsildar's order.
Tahsildar 176 to 177.
No,
No, that's continuing. The first two
Finding.
pages are the continuing.
Appendix
That's
A.
appendix. It's continuing.
Appendix A is the.
It's continuing.
Yes.
Page 190 is also get it.
Detailed findings as appendix A. Yes.
The findings. In such, the petitioner, Kartik Sardeo, is stopped from claiming the entire property. Then the lordship is basing on the opinion that the petitioner entitled to share as per the orders of title suit. Lordship get that. That is in the last part.
After hearing both sides.
After hearing all parties.
187.
No, but it is better to quote this part.
Sir,
The first at page 170.
yes. 170 is the
Yes.
170, keeping in view the documentary evidence.
170. So lordship is referring to 170.
170.
170. No, 170.
170 is your high court.
176, sorry, 176.
176 is the order keeping basically
Keeping in view.
claiming.
So this is the conclusion.
No, Milord, this is the no, this is the Milord contention.
No, no,
No,
no.
keeping in view. Thereafter, the case is discussed in appendix.
Yes, Milord, but findings are appendix. They made it appendix.
Finding that is
Yes,
So the
that
operative-
is the
This
conclusion.
is the operative portion.
Entitled to respective share in the entire property as per order of titles. You also got it, right? 177.
we need not enter into the we need not refer to the findings recorded by the Tahsildar in view of the nature of the order which we intend to pass based on rival submissions advanced on behalf of the parties in the present case. Now stop. The who preferred appeal? You preferred
Yes,
appeal.
yes.
The respondent number 4 preferred an appeal against the said order of the Tahsildar before collector. Sorry, ADM
Sir.
Sundargarh,
Registered.
which gave rise to miscellaneous appeal number 11 of 1993. Stop. The ADM Sundargarh allowed the appeal and held as under
Page 205, ma'am.
2010.
205, last 4 lines. Now, after hearing the learned advocate perusing the lower court case record and other relevant document, I find that
So the
the
conclusion,
date of judgment is
205.
the conclusion,
Four-
210.
205.
Conclusion, you-
There.
No. Now after.
that's a fine. Conclusion. is
But
two-
that is not there, what you are saying.
In 205, he has analyzed.
Analyze.
But where
Conclusion.
is the finding?
The 210 is the conclusion.
210 is the.
From 205 onwards
210.
is the fact which has been discussed. And the finding arrived at the law of primogeniture is applicable to
Section
Hathi.
59
That is
of the
different.
Code of Orissa.
My lord.
What you are asking,
And-
asking for 210.
Allowed the appeal, set aside the order passed by
Question now.
Tahsildar and concluding as under page 209. The question now is whether what's the court? Stop.
Still
next.
With this observation.
Huh?
With this
Ah,
observation.
with this observation. Appeal is allowed. Up to appeal is allowed. Stop.
Page 210.
Section 59 has also been, section 59
Yes,
has
that
also.
is also included.
Yes.
Okay.
Mr. Patil and senior counsel appearing on behalf of the petitioner assailing the order passed by the appellate authority has passed by the additional district magistrate ADM has submitted the order passed by the ADM Sundargarh dated 4/11/1996 is under challenge in the present writ application. First off, during the course of hearing of the we have heard so and so. Pleadings, counter plea, you have filed your counter affidavit?
Yes, sir.
Counter affidavit.
State
Affidavit
also
have been
filed the counter.
filed on behalf of the opposite parties. Yeah, respondent लिखवाते हैं ना उसको opposite party लिखवाते हैं. During the course of hearing of this case, it has emerged that it has emerged that neither the Tahsildar Birmipur, Birmitrapur, nor the additional collector, additional district magistrate, Sundargarh, has emerged that Tahsildar Birmitrapur did not have the jurisdiction. Which page is that?
The order.
What's not have jurisdiction to entertain the application for, where is that, Mr.?
That was the suo motu proceeding initiated by the Tahsildar after disposal of the writ petition by the Honorable Court under Annexure 11.
For
Entertain the issue or the dispute.
no, that release, the power of release is granted is
Under section 59.
59.
Court of Orissa. Fifty-eight is adjudication, 59 is release.
59.
58 is adjudication, 59 is release.
If the court will found it is a dispute between two wards,
To entertain the dispute for release of the property from superintendents under section 59 of the Odisha Court of Wards Act
1947.
1947. First off, section 59 reads thus. Section 59 of the Act reads thus. The definition of court finds place in section 4 bracketed A of the Act, which reads as under: the court means the court of wards. First off, the court of wards has been defined under section 5 bracketed A, bracketed 1 of the Act, which states that the revenue commissioner shall be the court of wards for the areas to which the Act extends. Stop. Subsection 2 of subsection 5 provides that the court, that is the court of wards, that is revenue commissioner, shall deal with every person and every property of which it may take or retain charge under the Act, or which may be placed under its charge by order of a competent court in accordance with the provisions of the Act. Stop. Subsection section 7 deals with
the manner of exercise of power by the Court of Wards, and states that court may exercise all or any of the powers conferred on it by this act through the court collector of the district, unquote, within the limits of which any part of the property of a ward is situated, or through any other person whom it may at any time appoint in that behalf. Full stop. The section 8 provides for an appeal against any order passed under this act by a collector to the court. Full stop. A collector of the court, a collector under section 8, collector, the expression collector under section 8, comma, in our opinion, comma, essentially refers to the collector of the district as occurring in section 7 of the act. Stop. Section 6 of the act is also a relevant provision for appreciating the dispute as to whether, appreciating the issue as to whether the Tahsildar or the collector, Tahsildar had the jurisdiction to entertain, to initiate a suo motu case pursuant to this court's order dated 25/6/1991. Stop. Section 6 confers upon the state government power to revise, modify, or reverse any order passed or proceeding taken under this act, whether a petition is presented against such order or proceeding or not. Stop. Next, on conjoint reading of sections 5, 6, 7, and 8, read with the definition of the court under section 4, bracketed A of the act, it can be easily deduced that it is the court of wards, that is, the revenue commissioner who exercises all the powers conferred, powers conferred on it by the act through the collector of the district. First off, the ADM and additional district magistrate cannot be termed to be collector of the district. First off, the collector of the district. First off, the section 7 envisages that the commissioner can exercise all the power through the collector. First off,
if apparently, comma, if any order is passed by the collector in relation to any dispute referred to it by the court of wards, comma, an appeal shall lie to the court, that is the court of wards under section 8 of the act. So stop. Next. Further, section 25 of the act contemplates that the court, comma, that is court of wards, comma, may make such orders and arrangements in respect of custody slash, comma, residence, comma, education and marriage of any wards whose person is for the time being under its superintendence, comma, of any minor child, comma, minor brother, comma, minor sister of such ward, comma, who, in the opinion of the court, is entitled to maintenance at the charge of the ward's estate, and the ward's ward apostrophe s next male heir being a minor and also entitled to maintenance. Stop. Section 26 confers upon the court of wards jurisdiction to appoint managers for the property, comma, and guardians for the person of any ward. So stop. Section 34 confers upon the court of wards a jurisdiction to order guardian or manager to make over the property, which reads as under section 34. Section 58 of the Act deals with the manner in which the adjudication of civil disputes between two or more wards is to be decided, and reads as under. Stop. Quote kar doge. It is section 58 of the Act
apparently states that in case any question arises between two or more more wards of such a nature that an adjudication upon it by a civil court is expedient, comma, it shall be lawful for the court of wards, comma, acting through the collector of the district in which a case might have been stated for the opinion of the civil court with regard to such matter under Order 36, Rule 1 of the first schedule to the Code of Civil Procedure, to file a suit having jurisdiction, comma, a statement containing the point or points of determination. So stop. In the present case, comma, pursuant to this court's order dated 25/6/1991, passed in OJC number so and so, the Tahsildar instituted a suo motu proceeding. Apparently, to decide the dispute between the petitioner and the respondent. So stop. In our opinion, respondent. Learned senior counsel appearing, Mr. Paril and senior counsel appearing on behalf of the petitioner has submitted that under the scheme of the Court of Wards Act 1947, neither the Tahsildar nor the collector had any jurisdiction to, we'll just come within 5 minutes.
ATMs.
Yes, sorry, ADM. Had any jurisdiction to entertain a dispute for and have you examined chapter 7, section 54?
Nature of representation in a suit, sir. That would be a nature of representation in suits. That would not be relevant here.
Huh?
54 would be in all suits, nature of representation. In all suits or proceedings in any civil or revenue court, the wards shall sue and be sued in his name, and the manager of property, if there is no such manager, the officer competent shall represent him. That is about representation in a suit, if there is a suit. Your lordships are concerned with 59. 54 would be a manner of a suit being against a ward or for a ward, then who shall be the, like a representations? Because like taking to be a minor or a for something of that sort. So Lordship,
Section 52 is a bar for civil suit.
Oh, that is different.
so Lordship, reference, I think
60.
59. I think Lordship, 59 is the season. 59, release, which
58
is considering release.
Section 58, if in the opinion of the court, it is expedient to get a opinion from the court, they may
He may
refer.
take.
Then he can
That's his
refer.
choice.
Refer.
That choice is his.
Choice is
That
with
is
him.
different.
59 is the power,
Which
and
the
58
collector-
is his choice.
Question arises
What's
as
acting through the collector?
two or more words in
Any dispute jurisdiction to exercise power under section 59 of the Act. Stop. He has submitted that such power lies exclusively with the court of award within the meaning of section 5 bracketed 1 of the Act. Stop. He submits that since the Tahsildar did not have the competence to exercise power under section 59 of the Act, the appellate power exercised by the additional district magistrate is meaningless. Stop. He accordingly contends that both the orders deserve to be set aside and the matter and the dispute should be remanded to the Court of Wards, that is the Divisional Revenue Commissioner.
Yes, actually
Which-
the words Act says revenue commissioner, but there is no revenue commissioner, there is a revenue divisional commissioner, that also let's make clarify. so that
Revenue
there's no
Divisional Commissioner
Yes.
of the Revenue Divisional Commissioner, which division?
Northern Division, Sambalpur.
Northern Division, Sambalpur. Within Sambalpur having territorial jurisdiction over the property in question.
Yes.
Situates within the district of Sundargarh.
Where the property in.
Where the territory under the property in question is situated. Stop. Next. Mr. Samal, and counsel appearing on behalf of the
OP number 4.
OP number 4, refuting the submissions advanced on behalf of the petitioner, has made twofold submissions. First off, he has relied upon the provisions under which order?
Administration of Odisha State Order 1948.
Administration of Odisha State Order 1948 to submit that the Tahsildar had the jurisdiction to had the jurisdiction as the Courts of Wards Act 19, Odisha Courts of Wards Act. This is Odisha Courts of Wards.
Odisha Court
Odisha
of
Courts
Wards,
of Wards Act
1947.
finds place in the schedule or what?
Schedule 2,
In schedule 2,
first column.
in schedule 2.
Page 94.
The schedule, Mr. Samal.
Schedule 2,
Schedule begins from
begins from page 74.
schedule 2,
Schedule 2 begins from page 74,
24. All right.
and the relevant portion at page 94.
Reading Odisha.
The Odisha is Schedule 2 consists with the Central Act, Bihar and Odisha Act, Bengal Province Act, and lastly to the Odisha Act.
Yeah.
Odisha starts at page 91. All legislation in the state of Odisha starts at page 91. Relevant portion is at page 94.
Just gives the, it does not refer to what is the purpose of this order.
Purpose of this order is paragraph 4. I have placed before Lordship.
Law to be applied.
This act will be applied. And the revenue jurisdiction has been mentioned in paragraph 6, revenue jurisdiction.
So this is nothing. Why are you referring to this? This means that this will apply. This act will apply.
This act.
That's all.
Lordship.
It is not that. He has further argued that in any view of the matter, an additional district magistrate is also a collector
Right.
within the meaning of section 144. You refer to 144
Yes, yes.
CRPC.
CRPC.
Yeah. Next. We do not find any force in the submission advanced on behalf of respondent number 4 that because of any provision under the administration of Odisha States Order 1948, the Tahsildar can acquire jurisdiction to be exercised. Jurisdiction. Okay. Now, power conferred. The power under section 59 of the Act stands conferred upon a Tahsildar or an additional district magistrate. So, top. Court of Wards Act
1947 finds place in Schedule 2 to the administration of Orissa Estates Order 1948. First off, the said Schedule 2 is referable to paragraph 4 of the said order, which simply mentions that the laws as contained in Schedule 2 shall apply in the territories, apply to all Odisha estates stop. Then the submission.
Paragraph 6 also.
You understand better than us, Mr. Samal,
Right.
Revenue jurisdiction, paragraph 6.
don't you?
All right, all right. Only the other submission was, the ADM has referred this
All
matter
right,
to
that is
section
there,
15.
that is there in our.
Yes.
Is there. The submission. So there are- the submission that the additional district magistrate can be treated to be a collector for the exercise of power under section 59 of the Act because of the provision under section 144 of the CRPC is not at all tenable. Top. Next. He has, however, submitted that he has conceded that the power under section 59 is to be exercised by the collector, by the court of wards, and therefore the decision of the Tahsildar or the additional district magistrate, the orders of the Tahsildar and subsequent order passed by submitted that the order that the additional district magistrate has clearly mentioned in his order that the same additional district magistrate has clearly mentioned in his order that the same should be placed before the state government for final decision.
Sanction.
Huh?
Yes, ma'am.
What is the language?
Language, section 59 of the Act of the Court of Arts prescribes that the court may, with previous sanction of the provincial government, in all cases where
No. What is the language used by the additional district magistrate?
My ADM, I am reading 210, madam. Page 210. Last paragraph. Section 59 of the Court of the Wards Act 1947 prescribes
Release of the state.
that the court may, with the previous sanction of the provincial government, in all cases where superintendence has been assumed in presence of the order under section 16 and 17 at any time, release from the superintendence of the person or property of a ward of both shall have to provide it.
Tell me. Has therefore rightly mentioned in the order that in the light of the finding recorded by him, the Tahsildar Bir Mitrapur,
being the manager of the court of wards, comma, shall move for sanction of the state government, comma, for release of the state from the court of wards in favor of
Respond.
respondent number 4.
The opposite party number 4, Mr. Khan?
Opposite party.
Yes, opposite party.
Opposite party. So stop. After having considered rival submissions advanced on behalf of the parties as noted above with reference to the statutory provisions under the Act, we are of the considered view that the language under various provisions of the Act is unambiguous. First off, Section 59 of the Act it is the court of wards, that is the revenue commissioner, who has the jurisdiction to release from its superintendence, comma, the person or property of a ward or both with the previous sanction of the state government, comma, in such cases where the superintendence has been assumed in pursuance of the orders passed under sections 16 or 17 of the Act. So stop. It is the court of ward, it is the court of wards which is required to have sanction for sanction of the state government or a release from its superintendence. First off, Tahsildar, indisputably, Tahsildar was merely a manager of the court of wards. First off, in that capacity, he did not have the jurisdiction to decide on the point of a release of property assumed by the court of wards, that is the revenue commissioner, in pursuance of the orders passed under section 16 or 17 of the Act. First off, collector of a district the power of the Court of Wards Act can be exercised through the collector of the district under section 7 of the Act. So stop.
in the present case, comma, the Tahsildar initiated a suo motu proceeding, considering himself to be the competent authority, comma, pursuant to this court's order dated 25/6/1991. Stop. In our considered view, comma, as the Tahsildar did not have any jurisdiction to initiate suo motu proceeding for release of the property for release of the property exercising power under section 59 of the Act, comma, the appellate order, the order passed by the additional district magistrate on an appeal preferred against the order of Tahsildar can also not be sustained. So accordingly, the orders dated so and so, Tahsildar and the ADM are set aside. So stop. This writ application is allowed. So stop. Since the let the Court of Wards, that is the Revenue Divisional Commissioner, Sambalpur.
You can call for the records, give an opportunity to parties and take a decision.
Sambalpur. Register a case. Sambalpur, proceed as the competent authority in terms of the observation made by this court in its order dated 25/6/1991 in OJC number so and so. So and so, and pass appropriate orders in accordance with law and the provisions of the Act after giving the parties due opportunity of hearing. Stop.
It will
be-
will appear in a particular date before the, all the
can
parties are
allow
before
with
your
a
lordship.
copy of the order.
It will be open for the Revenue Divisional Commissioner to call for the records of miscellaneous case number 1 of 1991 and appeal case number
11 of,
miscellaneous appeal case number
11 of 93.
93
ADM Sundagar.
11 of 1993.
From the court of from
ADM Sundagar.
ADM Sundargarh. for proper appreciation of the issues involved. First of all, as the matter dispute has remained pending for
It is-
several decades.
Since 1940.
So
Several decades, we expect that the Revenue Divisional Commissioner, being Court of Wards, shall expedite disposal of the dispute. Stop. London Senior Counsel appearing on behalf of the petitioner and London Counsel representing respondent number 4 have submitted that the parties shall appear before the Revenue Divisional Commissioner with a copy of the present order on 2 weeks hence.
Right.
Date
Yes.
0.
Okay, the date.
whatever date they.
So stop. Let it be done. Stop. This application is allowed. Okay, proceed.
Can it be specific time? Thomas conduct.
Connected rate application. What is that rate application?
Can it be
That
within
connected
6?
writ petition was filed by some, I think, the purchasers while the manager in Court of Wards. Since this is being remanded, your lordship may say that
The
can be
infrastructure stands disposed of
disposed of. Some properties
In
have been acquired through.
in the light of this order, in light of the present order. Cause title both. of them.
Not. But the
Can
learned,
it have
the
any-
learned counsel for Pinnabu was wanting to say that can your lordship fix a time for disposal? I thought it would
It is-
not be proper,
It would not
no,
be
not be
proper.
proper to keep the matter.
Maximum the after
See, law-
6 months, 9 months.
10 years.
It
We
is-
cannot
we have-
write.
Since the matter has been
Mr.
kept here for
Samal, we
years.
cannot write that it should be decided at least within 5 years.
So now the matter once the matter is so much in the
Let
High
us
Court,
see.
a
If-
natural
If
spontaneous.
there will be there some.
No,
pressure
your lordship said expeditiously that should be.
Expeditiously.
And all the
Expeditiously.
parties will appear, all the parties will appear on 10th or 11th of September.
That's 11th September.
11th September.
Yes, grateful.
If it will be 6 months or so,
Expeditiously, I think.
Expeditiously.
it has very
Because
long.
the
No, no, but
moment,
when
I was
we have
thinking,
kept
sir,
it here,
all matters normally you'll also direct, but I was thinking that the
we have kept
moment
it
the
28 years.
authority will see that, then the natural thing will come to mind that the Honorable High Court kept it for 35 years now. It would see.
And
28.
he is right in his,
On several occasions, both of us
No, that,
Started
we are
this-
not, that's a different issue, but
just, yes, he is right. That this matter remained pending before this court for 27 years.
Mal.
so that's the reason I also didn't say so.
So,
We-
and what have we done? Absolutely nothing. Back to square one.
91.
Both,
The original case was
Yes,
disposed of.
yes. You have gone back to that stage. Unfortunate, but
grateful. Well, at least, my lord, to that extent, we are grateful that it could be closed after 20. What used to happen, my lord, since it is over, I can tell your lordships, both of us, when we are coming to ready for this, seeing that the dispute of 27 years, seeing the dispute of civil court, because nobody thought about the fact that it doesn't have jurisdiction. They thought that they have to go on merits to Gangpur state, to that courts, and then they used to normally, I mean, I did not say further. Grateful, sir.
Item number 4.
This item number 4, in fact, it was there in the board on last week. Almost, the lordship had expressed the opinion in the last order. Let me kindly find. It will be clear.
your lordship
exchange-
has a very poor memory.
Exchange of the lands matter, Lord. The property was exchanged, my property was exchanged, so that's how the proceeding initiated. The petitioner's property was recorded in the name of the state, then with the property which.
Exchange thing.
Yes, exactly. On the last occasion, your lordship find that since in an earlier writ petition, an observation was made, that observation has also been quoted, that the exchange has not been given effect to. That has been quoted in the your lordship's last order. That order is also available on record. So,
So you want to pursue or?
so your lordship, after that you withdraw this so that you can pursue my remedy in respect of the property which has been recorded in the name of the state. I bow down to that, but before that, may I place a few, some options. I have taken instruction from my clients. Kindly have a glance at this. This is the record of right which has been prepared. I am also supplying a copy of the record of right to my learned senior in the state.
Mean to say, as per the record of rights, exchange has been effected.
Yes, that's exactly what I am saying. This record of right is in one khata. Kindly have a turn to page 2. Both the plots stand in the same khata. The plot number 762, which the petitioners got, but that has been recorded in the name of the state in the same khata. Next plot 1747, which the petitioners left for the state, that has also been recorded in the name of the state.
Both.
Both. Now there are two photographs also I have supplied.
1747. That is Gramya Jungle.
Jungle. This is Gochar, but in fact this is not Gochar. In fact,
762 was yours.
No, 762 belongs to the state.
Oh, right. Gochar, he wanted that it is
Yes.
that is
cultivable.
observation is.
And this is jungle, so he wanted to exchange.
So the next page, kindly have a glance. Two photographs I have given. The Gochar land which has been indicated, that is not fact. In fact, that is not a Gochar. And that is the reason this honorable court on one occasion directed the learned Tahsildar to make an inquiry, but it has not been done till date. And the plot which is there on the next page, it is being used as a burial ground by the villagers with some tiny worship places. What I beg to submit, not in the alternative, if it is already there in the name of the state which I have already given, and this plot now a house is standing, if the state may
That cannot be.
no. Next option, Lord, I am prepared to purchase it from the state, the present, for price.
See, if you want to purchase my property,
For price.
then you don't have any right to
No, I
purchase my property.
No, only if I accept the title of the state, I can purchase. I am accepting. Let it be there.
Gochar.
Yes. No, because in fact, this is not a Gochar, but it is wrongly recorded. And that inquiry may be conducted. If that, in that case, I am getting my property on price. I am prepared to pay. All the petitioners, they agree.
No, but in view of this, what can you do?
Pardon?
In view of the order which we have
Yes,
quoted,
Lord, I am accepting that order. Not been given effect to. Now the property belongs to the state. Lord, for the last 50 years, if I am having a residential house over the same, now I am prepared to pay for that. The price.
Very good.
I am paid for.
See, they have a right to acquire our house also.
I don't dispute that.
So go leave the house, they will use that.
No, my lord, now they have not pursued the eviction proceeding. It is the villagers who have pursued.
They can do that.
It is the villager. No,
Because it is Gochar land, they have a right to pursue.
I don't dispute that. Lord, because in fact it is not a Gochar and a residential property. That is why I am praying.
Residential property, you have made it.
Yes.
So you have made it, so you cannot see if you construct your a house, which Maidan is there?
Sorry?
Main this thing, ground. Playground, yeah, the way meeting there, those ground.
Killa Maidan, Killa, Barbat, the Killa Fort, Killa Maidan.
Yes.
So if you construct a house,
I'm
and
not-
you say that now it's no more.
There is a background of exchange. You kindly glance at the past incidents of this case. Not that suddenly they have constituted it. And in the alternative, I'm prepared to give the price.
You can resolve it. You can approve it.
One thing also, nobody can sell the land. Even the state government can sell the land because it's a Gochar land.
Sure.
He can approach the collector for alienation.
If it is not-
By initiation of alienation
Then
proceeding.
with the
Lord,
liberty that I can pursue my remedy in respect of
And counsel appearing on behalf of the petitioners after some argument seeks permission to withdraw this writ application with a liberty to pursue his remedy before appropriate authority / forum / court of law of this.
In respect of the property which he submits that he has given on exchange to the state.
So we will not say anything.
Lord, there is some observation, Lord, my submission may kindly be noted. Because I have my property which
If you
His prayer in the
see,
interpretation.
if we consider your submission, we record your submission, then we will have to deal with them. We'll deal with them.
back to, I can be for.
We are ready. Oh,
I also bow down to that,
writ application has been filed, seeking following relief. Purpose.
We'll quote your prayer and then.
Yes,
that
yes,
may help
definitely.
you. All right. There are two.
Both the cases.
Both the requesting there. One,
Whatever the prayer.
is, can I get some protection because the eviction order is there.
Item number 5.
Please, Your Lordship.
Yes.
But in the last occasion, Your Lordship was pleased to hear the matter regarding that applicability of section 68 vis-a-vis section 25 of the Orissa Hindu Religious Endowment Act. Your Lordship may kindly recollect, so far as the property is concerned, I have filed also a written note of submission. I have been in occupation of the property, having my residential house right from the date of my ancestors for last 50 years. The property was purchased from a person against whom.
So according to you, that section is not applicable.
That section is not applicable.
59.
That is not applicable.
59 or something, no?
68, Your Lordship, is not
68.
applicable. That is against a trustee or anybody claiming under him. As Your Lordship was pleased to read
Yes, he
that
appears
provision.
to be right in his submission.
My lord, and one more aspect is, even 25 may not be tenable for the region. They had instituted a suit, which came to this court, again went back like that. After finally, the suit got dismissed. So there was a suit against my vendor, claiming relief in the civil court, which was sought to be adduced by way of additional evidence for the revisional forum when I was relegated to the revisional forum. After the revisional forum did not accept those documents and also affirm the finding.
No, now I remember. This is 68 versus 25-2. This is the question.
Yes, my lord.
And
Last occasion, on the basis of the decision cited before your lordship said that 25 is in the, no, my lord, well, because I'm reading that decision again,
Please.
it has to be, yes, ma'am. Your lordship,
See, we rely on sections more than decisions.
yes, my lord. That is,
Show us the decision.
Radha Mohan Mahapatra and others versus Commissioner of Endowment. My lord, here is a case, my lord. Here the purchase was made prior to 27. In the year 27, my lord. By then, the Endowment Act, the provision of section 19 was not there. So that is why, my lord, this court, this honorable court, my lord, on the basis of the fact that, I'm placing that relevant portion, my lord, paragraph 3, my lord. Paragraph 3. Paragraph 3 of that decision, my lord. May I place, my lord?
Press it.
Yes. So far as the applicability of section 68 of the Act to the case of the petitioner is concerned, the language of the section clearly shows that a proceeding under section 68 can only be instituted against a trustee who has been dismissed or suspended or is otherwise not entitled to be in possession when prevents the newly appointed trustee from taking possession of the endowment properties. Further, Section 68 of the Act has no application against a person who claims the property in good faith on his own account. The explanation to Section 68 of the Act says that a person claiming under alienation, contrary to Section 19 of or Section 24 of the Act, shall not be regarded as a person claiming in good faith. In the present case, the alienation in favor of the petitioners being prior to commencement of the Act, it cannot be said that the alienation in favor of the petitioners are contrary either to Section 19 or Section 24 of the Act.
So therefore, the
Secondly-
facts, Mr. Counsel, the facts of that case may be different, but the law is same.
No, law is, my lord, both Section 24, Section 68 and 25, both are maintainable, my lord.
Both are.
So 68 is not, it cannot be said any order passed under 68 is without jurisdiction. No, my lord, that cannot be. That
if
is
we
what
say
I want to
And
point
if we
out,
say so, then
my lord.
if we say so, then you are saying can't be said. And if we say so, then what will happen?
My lord, what I beg to submit, my lord, the provisions enumerated under 68 as well as Section 25, both are two parallel provisions, my lord. Both are applicable. In the instant case, my lord, 68 is applicable.
All right, all right. We,
I will
just a minute. What is the difference between 25(2) and 68?
Yes, the only difference is that there the person gets an opportunity to challenge the order before the civil court, my lord.
All right.
Yes, my lord. Civil court
All right,
now.
we have understood
Yes,
you.
yes, I am coming to that, my lord. Now, the only question to be adjudicated, what he is saying, that he has been evicted in a summary proceeding under 68. My lord, he will resort to the remedy by filing a suit, my lord. The only question available, because now the fact of the case, my lord, he has purchased the property from one Krishna Patra and Sukuru Behrani. Those are no way connected to the deities. My lord, they are outsiders. They don't have any title over the property. On the basis of that sale deed, he is claiming his title over the property. On the other hand, deity is the recorded owner. The property index of the deity stands in the name of the deity,
All right.
and it is the property of the deity.
All right.
Now, my lord, the only question which he can urge is the question of adverse possession, whether he has the integrated title of by prescription, that he will raise in a suit before the civil court. Now, my lord, your lordship will the adverse possession against the deity cannot be claimed, that has been decided by this honorable court. That deity is a perpetual minor.
One breath you are saying that he can file a suit, then you are saying suit is not maintainable.
Yes, Section 27 bars. Section 27 is a bar also to file a suit.
All right.
And there is a provision, my lord. Here in this case, I am placing that decision, my lord. That decision I have given in the citations note.
That is not the question. The main question is whether 68 was applicable or not. That's all.
My lord.
Whether Section 68 was applicable or not, that is the only question. No other.
Section 68 is applicable, my lord.
According to you, it is applicable.
Yes, I
According
will
to
show
him,
the
it is-
decisions.
What
He has shown a decision. I will show a decision, my lord.
What
This
is it?
honorable court. Your lordship may kindly see. There you go. This is a decision, my lord, reported in 2003, volume 1, OLR 145. My lord, paragraph 2, my lord. I am placing from paragraph 2. The additional assistant commissioner of endowment noticed that the claim was permanent tenancy as granted by the prior hereditary trustee. He found that the grant of lease of the nature, even if the case is true without a sanction under section 19 of the Act, made the lease void. That the occupation of the petitioner herein was unauthorized and they could be evicted by way of a proceeding under 68 of the Act. The additional assistant commissioner of endowment and also found that there has been no proper tendering of rent by the petitioners herein.
So the facts
Thus-
are entirely different.
Yes, not.
Facts of the case are entirely different. Don't waste the court's time.
On the first paragraph, it is obvious that they had got it through a trustee.
Through the
That is why-
trustee, but the third party interest me.
All right, we have heard you.
That is why section 68 is applicable.
But 68, it cannot be said that 68 is without jurisdiction, my lord.
Mr. Counsel, we have heard you.
Yes, my lord.
All right. Dictate for me. Dictate for me. All right, next Thursday for judgment. Lord, we will dictate judgment in the court.
My. The other part I was just pointing out that even the suit also filed by them has ended in my favor also. That part I was.
That is that
Item-
you cannot bring because this is a certiorari proceeding. You cannot introduce new facts. Those are on record. What is there on record that can only be said, my lord. He has he tried to adduce those documents during the initially there was the things which he wants to introduce, my lord. It was not in the pleading. My lord, at the revisional stage, he filed an application under Order 41, Rule 27.
I'll explain that.
No, it's all right.
That's posting it to next Thursday. I will explain.
We will decide this matter only on the point of applicability of section 68, nothing else.
Yes.
Item number 6.
Yes.
All right, very please, Your Worship. The basic question that I raised before Lordship is, number one, the order passed by the authorities, non-application of mine in spite of remand made by the Honorable High Court. The High Court order has not been complied with in letter and spirit.
Where is the order? Is the order impugned?
Already, if Your Worship kindly see the order implemented. Only problems are actually I am not able to read properly because of infection in my right eye.
All right. So save. For our protection also.
I was requesting my senior that better not to also
All right.
stress the eyes, not because
This matter on
Because of cold, I
Next
think
Thursday.
some
next Thursday.
right eye.
Item number 7.
But can it be
Thursday.
the next.
Next.
that interim model is there?
Tomorrow shall continue.
Item number 7.
Please. With your Lordship's kind permission, I will confine my submission to a limited point. But if your Lordship permits me, I can file also a note of submission date chat to assist.
What
your
is the
Lordship.
limited point?
Limited point is, my lord, a revisional power purportedly under section 38B of the OA Act was exercised.
Yeah.
More than 25 years after the settlement of the land in question. The question was
38B, there is no limitation.
there is no limitation. Your Lordship in judicial pronouncement has been pleased to hold that there should be reasonable time. And there should be a reasonable justification for exercising power. There is absolutely no limitation. I bow down to that. But there is another factor to this. I moved this noble court challenging the initiation. This noble court was pleased to observe that I should raise all the points, including the point of limitations, before the revisional authority. Now, revisional authority order is confusing. He says, I am exercising power under section 32 of the Orissa Survey Settlement Act. If your Lordship will see page 33, Annex 9. But he exercises his jurisdiction under 38B and then says, Honorable High Court has not directed me anything. That your Lordship will find page 37. He says, the opposite party number 10 has also filed the writ petition number so-and-so, which was disposed of on 14/7/2008 without any direction to this court. So this is a wrong. He has not then considered the question of limitation, whether he should exercise his power or not after such a long gap. Though the direction of this noble court at page 32 was specific to the extent, accordingly, the writ application is disposed of giving liberty to the petitioner to raise all her points before the member board of revenue, including limitation, which shall be considered by the said authorities.
There was no limitation.
My lord,
There was no limitation.
limitation is question is when he should exercise the power.
No, reasonable time and limitation, they are two different concepts.
Even I can challenge that on merit here also, saying that he should not have exercised his power after so long. That is the also a pronouncement of this noble court, honorable apex court also, that the power has to be exercised at a reasonable time. On that aspect, I will assist your Lordship next Thursday if your Lordship keeps it. That is the only point, my lord. If your Lordship entertains here directly on merit.
Order of this court?
Order of this noble court is at page
31.
31, my lord. Grateful man, 31. It commences from 31.
You have not filed your affidavit.
My Lord Senior took time to file affidavit.
No, I took time to file affidavit, but last occasion I said I did not file. I considered I will not argue because it's a subsidiary proceeding. Only question of law, my lords. Yet I will address your lords. Only question is that when the land was originally settled with the original owner, my lords, in fact there was no document before the my lords OA collector, that is the Tahsildar, to settle the land in his favor. Only on the basis of a my lords rent receipt and Hathpatar, the land was settled with him, my lords. Because at the vesting of the land under the OA Act, the Jamabandi, that is the tenant ledger, has to be submitted by the intermediary before the OA collector, showing the possession of the person in whose favor it is to be settled. There are no such documents. Even the report of the RI Revenue Inspector says that there are no such documents. Only on the basis of possession note given by the RI, the land has been settled. That is the finding given by the learned revisional court, saying that the settlement at the initial inspector original Sahu is bad. So subsequent purchasers have no right to claim that land.
Where is the order of this court?
Which the
Page 31, Lords. Previous order remanding the matter for fresh judgment, not remanding. In fact, at the time the revision was pending, they had approached the Honorable Court saying that the revision is not maintainable. So Lordship fixed a date saying that dispose it up within a reasonable time. That is all, Lords.
I challenge the very initiation.
Yes.
Initiation, the
Notice,
observation was.
challenge the notice they came here. Honorable Court said that no, you contest the case and let it be
And
disposed.
here,
Here's all the points which will be decided.
there are 10 purchasers. He has been proceeded against. All have constructed their house after settlement because they have purchased. I have delineated the sequence of events in my dead chart. I'll file it, my lord. I'll assist also on the point of question of equity also. Your Lordship may fix a date. I will assist on that also. Since my learned counsel for the state is also addressing on the merit aspect of the matter.
You're saying other purchasers are continuing.
So much, all are, my lord, staying, having their residential houses now. It's a settled thing. They want to unsettle by way of exercise of power under 38B. But what was happening, my lord, one thing I beg to point out, my lord, when the Tahsildar was settling, there is need of a confirmation by the member board of revenue. During those periods, my lord, that was not being done. That's a mistake. I have to point out that that was a mistake because that need of confirmation under the OE Act. So, my lord, taking advantage of that, long after, my lord, this 38B is being exercised. That your lordship will see whether they should be exercising or not. That point I will assist your lordship.
So if this is your submission that your point of limitation was not considered, and you don't have any point on that.
Well, that I'll show to your lordship.
Limitation is not.
It's not a question of limitation exactly. It will be a question of that employment of that word.
Say that he can raise.
I'm sorry.
Limitation.
After how many years was this revision?
81 was the settlement. Thereafter the purchases. Now the impugned order is of the year.
Not impugned order. When was the revision started?
Revision started, that is 2004.
25.
81 is the settlement, my lord, 2004.
See, you had raised this point, specific point in your earlier proceeding. In your earlier proceeding, till previous proceeding, you had raised this point that 25 years is not a reasonable period. All right. So the court did not say that it should not have, the proceeding ought not to have been continued against you.
The Honorable Court said that you can raise it there. Then we will come back.
See, now he is raising plea. That after 25 years, it should not have been initiated. In the earlier proceeding, said that all right, you can take that plea there.
Was there? See.
Apply. Item number 8.
May please. Challenging the resolution order annexure 4.
Annexure 4.
4, my lord.
What is
They are
that?
the present petitioner, they are the lecturers of the aided college, my lord. And they have prayed for the benefits under the 5th Pay Commission of ORSP 1998, my lord, which has been not given by to the present petitioners on the ground that the notionally they have fixed it. Notionally they have fixed that from 1196 to 30th 9 2002, my lord. They have not given. Whereas in 9.1 clearly provides, my lord, Rule 9.1, my lord, clearly provides, my lord. In respect of the government college and aided college, they are entitled to get all the benefits, my lord. And that has been extended to the government college. In respect of the aided college, they have not extended. Your lordship has given a small note.
So,
and the
Mr.
citation
Puntia,
is
you are appearing on behalf of Mr. Rai, whose last date we had discussed,
I
he
have-
came and mentioned, so we
I have
on his behalf also. Otherwise, suddenly he will come and say, I have not been heard.
I have my power in there.
I would note of it.
Not at all. Government.
What is your grievance?
My grievance that I am entitled to get from the date of entitlement, my lord, 1196, my lord. Till they have for the notional they have fixed. And that period I am entitled, my lord. Since they have extended the benefit to the government college and other staff, my lord.
But that,
And whereas the 5th, 6th pay commission and 7th pay, they have extended the benefit. Only
They
that
should
period
not
they have
have-
not extended.
so
They
that,
should not have extended that.
Yes, yes. They have extended to the government college.
then we are challenging the resolution which discriminates.
Yes,
between
yes,
both.
Mike. Yes, Mike.
Say that. This, because of the resolution, they are not getting.
That has been decided by this honorable court, my lord. I have given court Diptirai case, my lord.
You have, no, no.
Diptirai case, Dr. Yudhishthira Khatua and the Vijayagatan Khatua.
Let us see the prayer. This is a note. Just given this note today.
Yes, actually. 4.
Without a judgment.
Good.
Diptirai.
Already.
This side, oh. So entire resolution you are challenging or the cutoff date?
They have only quoted
Only cut-off date.
cutoff date.
Let us see a prayer.
Fifth pay commission benefits. That
But
is,
they have extended 6th pay and 7th pay also. Benefits.
They said, where is it? With effect from 1st January 1996.
Ma-
96 means 28 years. When is it? When-
already August 7th pay commission, 6th pay commission. It relates back to 5th pay commission.
You are challenging annexure 4.
Yes, my lord. Annexure 4.
Annexure, what is there in annexure 4 which
Your lordship.
grieves you?
Yes, my lord. Your lordship turn to page 14, my lord.
14.
40.
Yes.
1/4 mile. They have given the revised scale of pay of the existing scales of pay as specified in column 2 of the annexure 1 shall be specified against it in the column 3. There are
Where are reading?
page 14, my lord. Bottom of
14.
the and para 4, my lord.
Para 4.
My lord. They have cut off given the with the effect from thereafter with the notional benefits with the effect from 1196 and with the actual
Slowly. Which paragraph?
para 4, my lord.
Para 4.
Bottom.
Okay. Scale of pay.
My scale up. They have given the cut-off date 1196. The notional benefit.
Oh, 1/10/2002.
Yes.
You want from
That period
1710.
that will be extended because they have already extended to the other government institutions. That is the only point. They
You're
cannot,
saying-
my lord.
You're saying why they are discriminating between government
Yes,
and aided?
9(1) your lordship rule 9(1) clearly provides. So I am reading out. Lordship.
Notional benefit from 1196 and
Yes,
actual
ma'am.
benefit from 110.
Yes.
So they have been given from 1196.
No,
Then
they have not given to the
government
government.
from 110.
Yes,
11, sorry.
1196.
Where is that resolution? Where is that resolution?
But they have extended, my lord. Only in respect of the aided education, so this resolution they have passed. To that effect, they have not issued any resolution. And Diptirai's case and Dr. Khatua also is well covered. And that has been, they have challenged it before the apex court, that has been confirmed.
What has been confirmed?
Diptirai case.
What is
Because they have,
Diptirai, you have to say what is Diptirai. Only saying Diptirai. What is Diptirai? Give the decision.
I have given the judgment, your lordship.
With this note?
Yes, my lord.
Okay.
Noted below I have given it.
But this notice was issued, this resolution was issued when? 2003.
2004 to OLR. Page 718.
Okay, this batch matter.
Yes,
My lord,
that's right.
Also, fifth pay commission.
Sent to the Supreme Court, that has been confirmed.
Which Diptirai?
Yes, this is. Just first. After the note. First.
This is by single judge.
See what it- Regarding extension of revised scale of pay, they said you are also
We are also entitled to that.
not related to that same resolution. Principle.
So what has been held in this? This does not relate to that circular.
So another resolution before that.
Yes, ma'am. That the principle is same, ma'am.
Which
Principle is-
paragraph?
Principle is same.
It had high schools.
High schools.
Huh?
These are only high schools, ma'am.
Let us
Para
come to
19,
the-
20, 20.
Let us come to the principle now.
Yes, ma'am.
Come to page 14. Paragraph 4.
Your Lordship. The
Okay.
revised scale of payment of
Now
the
come to
page 14, ma'am.
come to page 15.
50. Ma'am. Ma'am. Provided, I'm reading, ma'am. Provided that an employee is aided a government college elect to continue draw pay in existing scale until the date on which he earns his next or subsequent increment in the existing scale up, or until the vacates his post or ceases to draw in that scale. The option of the retain the existing scale under the proviso shall be admissible only in respect of the one existing scale. The option under the proviso to para 5 shall be exercised in writing in the form appended to Annex C so as to reach the authority mentioned in sub para 3 within 3 months from the date
So
of
if
the
it was not acceptable to you, you could have elected.
we have exercised our option, my lord.
You have exercised.
Yes, ma'am.
To
To the government, my lord.
when?
Under Annex of your lordship, kindly Annex 2. May I read it, sir?
What option?
Revised scale of payment.
You accepted that.
Yes, ma'am.
Pay notionally fixed. Serial number 10. Pay notionally fixed from 1196 onwards, or the date from which the revised scale is opted for, whichever is later.
All right, we'll consider. Yes, who is for the
I'm appearing for the state, my lord. I'll
consider? Second half. Second half. After recess.
after recess.
My lords, with my lord's permission, may I make a small mention?
Who are directed
What is
to,
your item number?
my item number is 37.
37. And your item number, Mr. Mukherjee?
43.
What? After this case is over. then-
Pardon to make a mention, Your Lordship. This is with respect to item number 22. My senior is in the VC and would like to make a mention.
My lords,
Yes.
This matter was included in today's list, my lords, by mentioning by Mr. Sridharan yesterday, wherein my lord directed us to file a memo. This just, my lords, needs to be tagged with the matters pertaining to extension notifications. And my lords, because we are apprehending coercive action from the department, that is why it was mentioned yesterday. My lords was pleased to allow this listing today. At my lord's convenience, my lord, it can be taken up at any point during the day, my lords. That is my humble request.
Taken on today?
Today, my lords, at any point at my lord's convenience, my lords.
Why is the matter so urgent?
Yes, my lord, because my lord, department is taking coercive action against us. That is why we mentioned yesterday, Mr. Sridhar mentioned yesterday before.
Regarding
my lords.
what?
My lord, this is regarding extension notifications. It needs to be tagged with the same batch of extension notification matters.
All right. Item number 20?
42.
22, my lords.
Move this matter along with batch of so and so. Into order. Yes.
Oblige, my lords.
Item 8, sir.
Yes, ma'am. The claiming the reverse scale of a mile under the wire speed 1998 miles. And that has not been extended to the period. In respect of the government colleges, they have already got the benefits and in view of the rule 9(1) of the 7(4) rules. That has not been extended to the present petition.
Yes.
And in number of decisions, my lord, already decided by this honorable court with regard to their entitled, my lord. Aided educational institution employees, they are entitled to get the revised scale of pay and all the benefits of a fifth pay commission. And
You may be entitled to, but the question is who will pay
government will pay.
and who will appoint?
Government has given, our service has been approved, my lord, by the government.
So someone will appoint you and the government will pay according to you.
No, because the granting rate is coming from the state government, my lord. Everything, my lord.
Yes, what is yours?
Your lordship. As far as fifth pay recommendation of the fifth pay commission is concerned, that was introduced by the state government. So far as state government employees is concerned, in terms of the Odisha revised scale of pay rules 1998, which was given effect on 3rd June 1998, giving retrospective effect from 1/1/96. If your lordship may kindly have a glance to these statutory rules. My lords may kindly have Rule 2.
Yes.
Save as otherwise provided under these rules shall apply to all persons in whole-time employment of the government. Then it shall not apply. They have carved out certain exceptions that these categories will not be included. But so far as this rule is concerned, this is basically applicable to the state government employees. So far as the petitioners are concerned, they are the employees, lecturers, teachers of aided educational institutions, colleges. So as such, this rule directly doesn't apply to them. Now, my lord, state government, so far as the aided, non-government aided educational institution are concerned, state government took a decision to extend the benefit, keeping in view Rule 9B of the Odisha Education Act as per Annexure 4, that is the government resolution. Lordship may kindly have a glance to that government resolution. That is at Annexure 4, page 13 of writ petition 16917 of 2011.
March 2003.
20th March 2003.
Yes.
May I just place one paragraph, my lord? Consequent upon the revision of scale of pay, teaching and non-teaching post in the government educational institution under Odisha revised scale of pay rules 1998, in pursuance to the finance department resolution dated so and so, have been pleased to decide to allow the revised scale of pay to their counterpart posts in aided non-government colleges with effect from 1st January 1996. Now, this resolution, this benefit was extended. Your lordship may kindly see
the next page, page 14, Rule 4. Clause 4 of the resolution, my lord. The revised scale of pay of the existing scale of pay as specified in column 2 of Annexure A shall be as specified against it in column 3 thereof with notional benefit with effect from 1/1/1996 and with actual financial benefit with effect from 1/10/2002. Then your lordship may kindly come to clause 10. Clause 10, that is at page 18. It's a non-obstante clause, but it reads, my lord, notwithstanding anything contained in this resolution, the pay would be notionally fixed with effect from 1/1/1996 and the revised pay would be payable only with effect from 1/10/2002. Now, this is the dispute, my lord. Benefits have been extended to them, but from a prospective date, actual benefits from a prospective date, and notional benefit with effect from 1/1/1996. That is, this is the dispute in the present writ petition. Now, my lord, if your lord, the argument advanced by my learned senior referring to 9B of the Odisha, the 1974 rules, your lordship may kindly have a glance to that rule. That is Odisha Education, Recruitment and Condition of Service of Teachers and Members of the Staff of the Aided Educational Institution, Rule 1974. This rule has been framed by the state government in terms of the provisions of the Act, Odisha Education Act. Your lordship may kindly have a glance to Rule 9. If my lord is holding the same book, that is
Rule 9, we are there at Rule 9, but there is no Rule 9B. Draw pay and
my lord,
allowances.
I'm sorry, my lord. Rule 9, my lord. Every employee of the aided educational institution shall draw the same pay, dearness allowance, and subsistence allowance in case of suspension as is admissible to the counterpart in the government educational institution under the relevant rules applicable to him and shall ordinarily be paid in the month following so and so to which the claim relates directly by the government or by any officer or by any agency authorized by the government. Now, my lord, so far as the operation of these rules is concerned, we have extended the benefit. The rule says they are entitled to the same benefit as has been extended to a teacher in the government educational institution. They have been extended with the benefit, but from a prospective date. Rule doesn't prescribe from which date it has to be given. Now,
see whether arrears of salary is benefit or not. This is a benefit or not.
This is a revision.
It's a benefit or disadvantage. See, 1/1/1996 you have implemented. You decided to pay them with actual pay with effect from 2002. All right. Arrears you have given to the government employees and you have not given to them.
Not given to them, man.
So that is whether that is benefit or not. Payment of or their right to have the arrears, whether there is any difference between them and the others.
But so far as the provisions of this statute is concerned, because their right flows from this particular statute, 1974 rules. Now, this rule has been framed in terms of section 27 of the Odisha Education Act. And may I take your lordship to the amended act, that is 7C. 7C of the Odisha Education Act. Your Lordship may kindly have a glance. Because the petitioners are all teachers of the aided educational institution. So they receive their salary component as an aid from the state government. So this revision is also a revision to the salary component which they receive in aid. So if your Lordship will look at 7C, 7C of the Act, my Lord. The state government shall, within the limits of its economic capacity, set apart a sum of money annually for being given as grantinate to the private educational institutions in the state.
That is different.
Then next, my Lord, no order according permission or approval or recognition under this Act, whether prior to or after the commencement of the Act so and so, shall entitle any private educational institution to receive the grantinate. So if they are receiving the salary towards their salary component as an aid from the state government, and that aid is subject to the conditions prescribed in 7C. So the pay revision that is subject to the, my lord, the economic capacity of the state. State decided to grant that benefit from a particular date. It is not that state simply said that you are not entitled. State said, yes, you are entitled, but from a particular date, subject to the economic capacity of the state. But this is one argument.
That is another C. Rule 9 states about their entitlement.
Yes.
They are entitled to draw. From where will they draw? It's a different matter. Whether they'll draw it from the grant in aid which you provide or the college gives to them.
This is by the state government and it is by the government.
It is by the government, then
Yes.
if you, the rule is there, then you will have to follow it.
But the rule, well, the conditions of the rule are subject to the provisions of the Act, my lord. Now, Act gives right to the state government to
say if you decide that one person shall be paid 50,000 per month. All right, then you decide about your economic capacity.
Yes.
Then unless you revise his entitlement, how can you say that he will not get that amount?
But his entitlement has been revised. But it has been paid from a particular date.
No, entitlement means actual.
Entitlement has been revised with effect from 1/1/96.
Yes. But notional payments have been made and actual payment made from a prospective date because of the economic capacity of the state.
Payment, notional benefit.
Notional benefits. That is only the pay revision. And the judgment of Dipti Rai they are referring to, that judgment is a case in 99. The state government took a decision to give the pay revision, but they maintained a stony silence. They didn't extend that benefit. They approached this honorable court that yes, the provision 9 says that they are entitled for the benefit. You took a decision to extend the benefit, but you are not extending the benefit. So that is why the court decided that no, you cannot maintain silence. You will have to extend the benefit. You are bound to give the benefit. So benefits were extended to them.
Regarding high school teachers.
High school teachers.
They were saying that you have given to the lecturers.
They were saying that once you have given to the institutions which were taken over by the government, and those teachers were extended with the benefit of pay revision, and you took a decision in respect of non-government aided educational institution that you will extend the benefit, but you are not extending the benefit.
This you are saying that it is from a prospective date. The resolution doesn't say prospective date. It is retrospective, but a later date.
Yes, the actual benefit from a later date. That is the only.
It is retrospective, but not the same date as the counterparts.
Yes, yes.
So the resolution is dated 2003. They have been given from 2002, I think.
No, but this rule is very clear.
That is not before this honorable court, but one of the cases was disposed of by the honorable single judge. Only on the ground that discrimination, only on the ground of discrimination that once benefit has been given to others, why not to them? But so far as the provisions of the rule are concerned, so we have preferred also a writ appeal, which is pending before this honorable court.
I think those matters are listed today. Because there have been earlier orders linking number of cases. But number of cases have been disposed of by the learned single judge saying
Representation to be considered.
You were there?
No, no, that is not done. Again, 2011, again it will go to the opposite party and they will consider the same thing will be happened, my lord. Nothing will be changed. And with regard to 7C, my lord, Dr. Judicial Court also judgment I have given the report in 2008 1 well, my lord. 7C has already been read.
And one of the judgment of Maharashtra State Financial Corporation. So, tax court judgment I am referring to. The Lordship will.
On what point?
That is the point. The 2 points were involved. One, granting the benefit from prospective debt and granting the benefit to the persons who have retired after the cut-off date. So far as retired after the cut-off date, the Honorable Court said no, they are entitled for the benefit. But granting the benefit from the prospective date, the Honorable Court said it can.
That can be done.
Yes.
But had you done in case of others also, the matter would have been different. Now the only question is their entitlement in accordance with Rule 9. That's all. So if Rule 9 says, then you will have to follow Rule 9 as it is. You cannot distinguish for the purpose of this payment of paid dearness allowance, subsistence allowance between the government teachers and these area teachers.
In case of suspension.
No, this I will have to get it with this and subsistence allowance in case of suspension.
Yes.
This is like pay, dearness allowance and subsistence allowance in case of suspension. As I was not counterpart in government educational institutions. Under the salary you paid in the month following the month. So within the month they'll have to strictly follow this. That's all. Yes.
And this particular benefit was extended to them from 2002. They exercised their option, accepting the conditions stipulated in the rules. Now, after accepting the benefit from 2002 onwards, only in 2015, they approached this Honorable Court. So, there has been a considerable delay in approaching the Honorable Court, that too after 10 years, without any reasonable explanation. And after accepting the benefit, can they turn around and say a particular provision of the rule is
They accepted the benefits.
Yes, my lord. The benefits they have accepted in terms of this resolution, but they disputed after 10 years that it should be from a retrospective date, not from a prospective date. And the conditions stipulated in clause 4 and 10. These are the subject matter of challenge in the present set of writ petitions, my lord.
What is the decision in Dr. Yudhishthir Khatua?
Used to go to your lordship. I have given the report in 2081. I will remember. The 74 Rule 9 payment of the donors allowance to the petitioners as being paid to the lecturers of the government college. Disclosing the facts and conditions held. Opposite parties cannot deny payment of donors allowances to the lecturers of educational institutions like the petitioner at the rate than at which such allowances is being paid to their counterparts in
But
government.
why,
colleges.
what is the explanation for delay?
Delay value 2011, they have, it is a continuous cause of action. They have approved the authority by the time and 2011, they have approved the.
So why did you approach in 2011? You could have
Yes,
approached in 2015.
Because they have approved the, they have approved the authority time and again, my lord. Since no action has been taken, they are compelled to approve the lords.
Where is the representation that you have approached? There's nothing? Nothing.
That has not. Because
Then it's very difficult.
You all have
Then it's very
retired. You
difficult.
must have
we have
retired.
already retired. Retired persons.
See, your money suit is time barred, you know.
No, your lordship, I see they have ops. It is a genuine claim of the petitioners, my lord. They have
Maybe, but you have approached this court after more than 8 years. Yes, that is against you.
Lordship, it is a continuous cause of action. It is a matter they have not considered because it is a genuine claim of the petitioners, my lord. And that has been decided, your lordship.
No, why should they approach? Let me clear up this call of action. Is whether any is there any decision on this point by this court? Huh?
No, my lord.
Because number of cases had been tagged together and directed to be placed before the division bench.
Yes.
Then it is found that many of those matters have been placed before the single bench and
Disposed of.
saying
Disposed of. My lord, one of the case of Jogendra Behra, the honorable single judge passed this order. Your lordship may kindly see. Provisions have not been referred. Only the honorable court proceeded on the basis that discrimination has been caused because benefit has been extended to others, not to them. And against this order, we have filed a writ appeal, which is pending. Well,
there is one order in their favor then. Others, it has been said this representation disposal.
and against this, we have preferred writ appeal, which is pending.
The conducted matters was tagged with the first case, my lord. The white order dated 13th.
Yes, that I've checked. Half have been disposed of by the learned single judge saying representation will be disposed of. That is why they could not be listed.
So there was some order passed in 18507 of 2011.
This was one of the matters which was tagged.
Not to this, my lord. That is.
See, come to paragraph 4 of the order.
Main contention of the council.
Oh, so he had come up
Rejected
in
by it.
2011.
No, no.
Thereafter representation disposal. That was rejected, then he came.
Yes, he had earlier approached, then representation was rejected and thereafter he.
So what is paragraph 4.1? Similarly situated employee.
That is, they are claiming the differential pay from 1196 to 39/2002, as has been released in favor of other similarly situated.
Lecturers again.
Yes. Here also, they are all
Lecturers.
Teachers.
No, lecturers.
Lecturers. Colleges.
But in this case, this petitioner had approached earlier in 2011.
11.
Then probably representation disposal, which was rejected.
Rejected.
Thereafter this order.
Thereafter this
Now,
order.
others had approached straight away, so I think that is why they have been relegated to representation.
Representation.
Yeah, come on.
Yeah, this is 2011.
15.
The matter remained.
11.
Here only the Honorable Court allowed this read on the ground of discrimination.
No, but who were the similarly situated persons? It is not mentioned in the order.
That is not mentioned in the order.
Maybe pardon my lord. WPC 26,968. WPC, that is
Batch case.
2013. They have denied the entitlement 2011, raising the delay and kindly peruse.
Why are you commanding us to project?
Sir. Thereafter, we have approached 11. Financial crunches upon the government. Same area dues period. Same period area dues, my lord, difference.
What for?
11 delay code, it was filed in the belated.
See, you were entitled in 2003. You were entitled in 2004 also. Why did you approach this court in 2011?
11 that order, then we have annexed that after denial to extend the benefit of fit pay commission area dues. Then somehow we have approached. And it is a continuation of cause of action, pay, pension, fixation of pay.
And against that Jogendra Behra case, we have preferred writ of will that is pending.
No, but legally they are correct. Delay is the only thing which is.
Yes. That writ appeal is WA number 1476 of 2024.
What is your ground? Delay?
Delay, and we have tried to distinguish Dipti Rai case that they are referring to. And
no, whether you had taken this ground of delay in that 2015 matter.
In this, there must be a counter.
yes, my lord, delay is a ground, my lord. Delay is a ground. That writ appeal is with me, my lord. Delay is a ground.
No, what is the ground in your counter affidavit? Jogendra, because Jogendra, this is the 13th order by which it had been disposed of. Others counters may not be there. Stand taken by the.
Not mentioned. So how do you explain delay? The delay is of 8 years. How can we know that?
No. There is a judgment we have got. There is a, we are citing one judgment, my lord.
What judgment?
That is,
Ask Mr. Mahapatra to cite. You have not seen the judgment.
yes, ma'am.
So far the revision scale is concerned, there is no limitation. In each month, the call action arose, 2-3 judgment on appeals court. I have already remarked
What?
that case.
What?
So far the revision scale of pay is concerned, that is a continuous judgment that arose in every month. That is the honorable appeals court phase.
Every
So
month.
there is no limitation.
See,
After-
that is not the case.
Yes.
Here is the case of payment of arrears. It is not a case of revision. The revision has been given. Notional benefits have been given. And thereafter, everything has been paid.
Just time.
The question, Mr. Counsel, please understand before
back.
citing a decision. It's a question of payment of arrears. Arrears up to 2002. 2002, the decision was taken in 2003. So it's not a question of revision. The revision, the benefit of revision has been extended. Don't cite a decision without
That is why I was telling, don't cite it without reading.
Has assured time and again to give the benefit.
Who has
So there
assured?
is a demonstration on
Report to
behalf
the
of the
government.
All Odisha College Teachers Association, and from time to time, government have already assured.
that.
to give.
Mister, you
But
can
that
do.
is in the newspaper, that is not.
Then you go, you get the news items published in the newspaper. Go and demonstrate. Why have you come to the High Court? You should not have come. And don't make these submissions. Make legal submissions only. Demonstration and publication.
The continuous cause of action.
Continuous cause of action. Can you file a money suit? What are you entitled to? What are you entitled to? Money? Or something else? Are you entitled to consequential benefits beyond that?
No, my content.
You are entitled to only arrears. You were entitled to arrears in 2003. You filed this writ petition in 2011 and you are showing us judgments. Continuous.
We have challenge the government resolution letter.
Challenge the government, you could have challenged in 2003.
Your lordship, I interrupt, my. Your lordship, let it come on Thursday, my lord.
All right, Thursday. On law, you are correct, but because of delay, we may dismiss your claim.
Yes. 3 years, your lordship, 3 years. After.
We are of the prima facie view that the writ application challenging the resolution dated 23/2003 claiming arrears of salary from 1/1/1996 so as to claim arrears of salary from 1/1/1996 till
30th September 2002.
09/2004.
filed 8 years after the impugned resolution suffers from the vice of delay and laches. So, learned counsel appearing on behalf of the petitioner or petitioners. Petitioners seeks adjournment to address the question of delay. Stop this matter on next Thursday. Petitioners. So many petitioners. So many cases.
Mention all the case numbers and.
Item 43. Sir.
Fine. Can go.
43, who is for the other side? Someone is there for the other side.
Yeah, please, Your Lordship.
Yes.
Having emerged successful in a tender and being otherwise eligible, the petitioner has not been issued the work order and hence seeks a mandamus from Your Lordships. Now, the background is like this. In June 2023, the petitioner was blacklisted on the ground that having qualified in another tender, he did not comply with the tender conditions of providing the original documents within a window of 5 days, and hence the tender was not only cancelled, but he was given a show cause notice and thereafter blacklisted. The petitioner challenged the blacklisting order before Your Lordships here, this honorable court, and the order of blacklisting was quashed. Now, thereafter, it was quashed, but in
WBG 19439 of 2023.
in August 2023, it was quashed. Despite the order of quashing the blacklisting order, the portal of the petitioner remained blocked, and it was only in another subsequent writ petition when this was pointed out that the portal is not being opened. It was opened 4 months thereafter in December 2023. Now, after December 2023, in February, the petitioner has participated in the present tender and he has emerged successful. And this tender was thereafter, for reasons best known to the state government, referred to the state for consideration as to approve the petitioner as the successful tenderer. It was sent to the state government, and the state government has been deferring it from one meeting to the other, seeking a status of the SLP which has been filed against the blacklisting order. Now, SLP in fact was filed. It was kept pending in a diary section with defects for a period of about 5 months. Thereafter, when the petitioner started making applications on the RTI for seeking information as to why he was not being given a work order, the defects were cured, and now the SLP notices have been issued, but no interim stay has been granted. Now, if Your Lordship takes the counter affidavit, in the counter affidavit, they fairly and squarely admit in para 7 at page 2 of the counter affidavit, 5th line into para 7, sentence beginning, it is averred the present writ petition that the petitioner number 1 emerged as successful bidder for the technical committee, and the decision of the technical committee was forwarded to the state government for necessary approval. Till today, no approval has been granted in favor of petitioner number 1, nor any work order has been issued in its favor. Hence, no right has accrued in favor of the petitioner company in absence of the approval of the state government. Well, nowhere in the contract does it say that the state government approval is required prior to issuance of the work order. If the DTCN have enclosed as a annexure, and thereafter, my lords, they go on to say in para 14 at page 6, the last line in that page, while the matter stood thus, on 14/3/24, the meeting was held in the conference hall of the Works Department presided by this is paragraph 14. Yes. I am reading the last line of page 6. While the matter stood thus, on 14/3/24, the meeting was held in the conference hall of the Works Department presided by the Principal Secretary of Works Department and other officers. The said meeting, it was entirely decided that the entire tender was placed before the meeting of the tender committee of the Works Department and the chairmanship of the Principal Secretary of Works Department held on so and so for discussion. After detailed discussion, the committee unanimously decided to place the instant tender in the next meeting of the tender committee for further discussion. So also the committee also instructed the chief engineer DPI roads shall submit a detailed report on the present status of the blacklisting order and blocking of portal of the recommended L1 bidder, so and so, and appraise the committee in the next meeting. In the meantime, the chief engineer DPI has submitted his report to Works Department
and stated that SLP has been filed by the state bearing diary number so-and-so challenging the judgment of the High Court in WBC number so-and-so. The said SLP is sub judice before the Honorable Supreme Court of India. Again, the tender committee was placed before the meeting of the tender committee of Works Department and the chairmanship of the Principal Secretary Works Department held on so-and-so. After detailed discussion, the committee unanimously decided to wait for further developments. At this juncture, kindly, my lords, see the minutes of the meeting, which have also been.
Mr. Mukherjee, you don't have a right.
My lord, I'll come to that. I know that is an objection will be taken against me. I will try. My endeavor will be to show to your lordship.
No, we are saying something else.
Yes.
You don't have a right to get the work, right? Get the contract. Then you were blacklisted. That blacklisting order has been set aside. So as on date, there is no order of blacklisting against you. You are qualified in all terms, right? Still, it is up to them to give that work to you or not. So they are employer, they are the final.
I bow down to that, my lord.
Particularly in the background of the fact that they have challenged this court's order in the Supreme Court, in which notice has been issued. So once the employer feels that the work should not be given to a person who has been blacklisted, and even if not blacklisted, they can decide not to give the work, then how can you enforce your right here?
I'll try to answer that, my lords. My lord, here is the question. There is a state. The state is to act fairly with all its citizens. And I am trying to seek to assert my fundamental right that is guaranteed under 19(1). Now, my lords, now kindly see page 90 for a moment. Page 90. Are the list of works where I had emerged as the L1 bidder in all these contracts.
That is not the question.
No, my lords, what I'm trying to make out is this, my lords. They have now, my lords, threatened my livelihood under Article 21. Because if they just go on denying me work despite my being qualified, and for what reason was I disqualified? I was blacklisted on the grounds.
See, we cannot go into that dispute.
That has been decided by your lordship. That matter has been decided in my favor by your lordships.
That matter has been decided, but the matter is pending before they have not accepted the order of this court.
No, my lords, they are not accepting. The position does not change there because the law of the land is very clear on that aspect. May I invite your lordship's attention to one judgment of the Supreme Court of.
The law, the decisions, the judicial precedents will apply based on the facts and circumstances of each and every case. The facts in the present case are peculiarly different from other cases where blacklisting order was passed, that order has been set aside.
There are similar cases to that effect also, where my lords, the courts have interfered.
All right.
Para 23, your lordship may see at page 9 of that judgment.
West Coast.
Yes, ma'am. West Coast. West Coast, they have.
There's no page 9, it be 700 something.
Top at the top, my lords, page 9, the second line.
The print one.
Print one.
Intern.
Okay.
Page 9, your lordship only takes that portion where they have quoted with approval.
It is there. Yes. Yes.
Well, here they have quoted with approval the judgment of the earlier judgment of the court in Kunhamed. It's a very famous judgment where the doctrine of merger was discussed, my lords. Now, the quoted portion, your lordship may take the third line. where a decree or order passed by an inferior court, tribunal, or authority was subjected to a remedy available under the law before a superior forum, then though the decree or order under challenge continues to be effective and binding, nevertheless, its finality is put in jeopardy. Once the superior court has disposed of the list before it either way, whether the decree or order under appeal is set aside or modified or simply confirmed, it is the decree or order of the superior court, tribunal, or authority which is final, binding, and operative decree or other order wherein merges the decree or order passed by the court, tribunal, or authority below. So, as long as the order is not set aside.
No, that is different. Why
That
are you
does
relying
not
on
say
this?
that. It does not say that. It says when it is set aside, then it merges.
Thereafter, the next quoted portion. Once a special leave petition has been granted, the doors for exercise of appellate jurisdiction by the court.
Mr. Mukherjee, why are you referring to these decisions?
Well, I'm referring to this to show to your lordship that when the matter is before the superior court, but no stay has been granted.
No, this is not on this point.
That is there, my lords. In the next paragraph, it is there. Next paragraph, it is there.
So this is, see, this paragraph explains
Yes,
the
sir. Doctrine of
circumstances in
merger.
which the doctrine of merger shall apply.
Sorry, my lords, I'm referring to a wrong paragraph, my lords. My lords, may I read from Kunhemet directly? I'm sorry, very much sorry that I don't have an extra copy, but I'm reading directly from Kunhemet. This is, my lords, volume 2000, volume 6, SCC, page 359.
That has been referred, but what is the
My
paragraph?
lords, the relevant paragraph is this, my lords. From Kunhemet, I'll pass on this judgment to your
What is
lordship.
the paragraph?
The paragraph number is
We will hear you on Monday, Mr. Mukherjee.
para 14.
Come prepared. You are half prepared.
Para 14.
We will hear you on Monday, Mr.
14 subparagraph.
We will hear you on
Monday at 2 p.m.
We thought maybe they will do something. Your anxiety is Supreme Court may dispose of.
Supreme Court, my lords, I'm helpless in Supreme Court, even in spite of mentioning before the court to finally disposal, it's not happening.
Can I take up this matter Tuesday, man? Monday, I have some personal too.
Tuesday at 2 p.m.
Okay.
Item 37, ma'am.
Item 37, you are for whom?
I am for the respondent.
So how can you make a mention?
Malad, because last occasion my friend is also there, Malad.
Is there any interim order?
No interim order is there, but your lordship dropped the contempt proceeding because of the pendency of this appeal.
Yes.
And on the last occasion also it was specifically fixed to be listed on
In this case, may I pray, my lord? Your lordship may fix item 37. Your lordship may fix it to Monday at 2 p.m. It can be. This is a matter regarding.
Monday we can, no, we can fix a date.
My lord.
Fix a date.
at a particular time so that it can
Date
be.
and time we will fix. Not next week, next week. 17th. 2 p.m.
My lord.
All right.
17th.
Item number 9.
Yes.
Sir, the sole cause of dispute in this matter arose when Mahanadi Coalfields Limited forfeited my earnest money deposit of ₹9,11,000 and terminated my contract. Although I have fulfilled all the essential commitments, they have not listened to my submissions, and illegally they have deducted my money from they have forfeited my bank guarantee. of
9.
Yes, 9.
9,11,000 rupees.
Ajay transport.
They have issued, sir, my lord, they have issued hindrance register, which clearly shows that I was never at fault in short transportation or less transportation. I have worked to the best of my ability and I have given all my services to them. In spite of all this, they have forfeited my earnest money deposit of 9,11,000 rupees. And after so many years, my lord, they have again issued a revised approval order in which they have restricted the penalty to 37,506.58 paisa. This is after 12-13 years of the forfeiture of the old amount of 9,11,000. Now they have revised the penalty to 37,506 and 58 paisa.
That's one. Have you returned the balance amount?
No, they have not returned.
You have not returned.
No, they have not returned. They have not returned.
All right. Mr. Modi, is it during pendency of the writ petition?
Yes, madam.
Right.
Yes, madam.
Have you filed that document?
Yes. In the additional affidavit, I have filed that document.
And you saying you don't know?
He has not sought one.
We have,
When he has filed it one.
When did you file the additional affidavit?
on Tuesday, madam.
Tuesday means today is Thursday. Oh, it is not there on record. Naina?
No.
This Tuesday, day before yesterday.
Yes.
Telephone. What additional affidavit?
Recently, that 5 lakhs that we have reduced to 37,000. That's been returned by Mr. Sanchez and now we are this reduction.
It is stated by the petitioner in person that an additional affidavit has been filed, bringing on record the development subsequent to a recent development of the said additional affidavit is not there on record. A copy of the said additional affidavit has not been
Where on record?
there on record.
Okay.
A copy of the said additional affidavit has not been served upon learned counsel for the petitioner or opposite party. Stop. Let the same be done. Let a copy of the additional affidavit be served upon learned counsel for the opposite party by when did you serve?
In 2 days, sir.
You have to serve a copy on the council appearing for Mahanadi Coalfields.
Yes, sir. Yes, madam. Yes, my lord. I will serve within 2 days, sir, madam.
All right.
By Monday. Next Thursday.
It will be listed next Thursday. Please do it by Monday.
Sometime I filed what is that?
It is your document.
That I will take it.
So you have 3 days time, Monday to Thursday.
Item number 10.
He's waiting.
Please, my lord.
12
My
years.
lord, I am appearing in VC, my lord. My lord, in this case, I have challenged the action of the opposite party bank, my lord, in forfeiting the bidding money, my lord. That is, that amounts to 5 lakhs, my lord, without giving any opportunity of hearing, my lord. My lord, the brief background of this case is that, my lord, kindly have a glance to Annexure 1, that is page 7, at 7. One auction notice was published.
We're glancing, but we can't read anything.
Yes.
Auction sale notice, my lord, where I participated in the auction, my lord, and I was qualified as the successful bidder. That is reflected at Annexure 2 series, page 8, my lord. Page 8. My lord, thereafter, at page 9, my lord, they called upon me to pay rupees 5 lakhs and balance amount rupees 15 lakhs to be given by 30/11/2011, my lord. And my lord, what happened thereafter? My lord, in the meantime, I came to.
Who is appearing for the other side?
My lord, SBI is there.
SBI.
Yes, SBI Bank is there other side, my lord. My lord, Devi Prasad Sadangi name is reflecting.
To take fresh notice or something.
My lord, they have already entered their appearance. They were appearing even, my lord.
It is not there on this earth, how will we appear? Are you not aware?
My lord?
Are you not aware?
No, my lord. My lord, then I'll take fresh notice, my lord.
But his son is along with him, but by then his son had not enrolled. Now only few years back he had enrolled. So notice better, notice go get.
This is, it was filed in 2012.
Yes, my lord.
Notices were issued in 2012. And thereafter 2017.
It was listed with singles.
Oh, 24.
Yeah, it was listed before a single bench in 2017. Thereafter, it has not been listed. Earlier, it was before a division bench in 2017 before a single bench.
It is single bench matter or division bench?
My lord, earlier it was coming before division bench, my lord.
No,
Thereafter,
then in 2012, might have been a division bench matter.
Now again, it has.
my lord, it is now against bank. It is also assigned to my
Division.
lord single bench since against bank.
Not if it is surface similar, then only division bench. Otherwise, all other bank related matters go to the honorable single judge.
My lord, it is arising out of surface A because the auction sale notice was issued
Under the
under
Surface
surface A.
You should notice. Huh? It is stated at the bar that the London council who was representing the opposite party bank is no more. Stop. Issue. There is no representation on behalf of the bank. Stop. Issue fresh notice. 1 week.
Yes.
Requisites. Yes.
Grateful, my
What? 6 weeks. Yeah,
No, the opposite parties are Bhubaneswar, but access can be delivered.
Item 11.
Grateful.
Item number 11.
Also surface side. Yes, what is
Madam,
it?
I am for the bank. It is a matter of surface here, madam.
That's what I noticed.
Has it become infructuous?
Yes.
There is no representation on behalf of the petitioner. Yes. default. And counsel appearing on behalf of the opposite party as bank has submitted that this application has become infructuous with the lapse of time. Be that as it may, Thomas says there is no representation on behalf of the petitioner. The said petition is dismissed for it.
Item 12.
Well, the PIL matter, my lord. The matter relating to proper protection and rehabilitation of livelihood of 45 number of middle class family. My lord, those houses are set fire by the upper caste community.
Well, this is matter of 2012.
My lord, on last occasion that my lord, on 22/1/2024, the state government taking time for obtain instruction whether all the petitioner have rehabilitated by the authority or not. Last order, my lord. Order number 16.
Yes. The affidavit has been filed.
No, I had filed an affidavit earlier saying that the status of the trial of the case, out of 23 witnesses, 9 witnesses were examined. That was in way back in 1 year back. And so far as this your lordship last order is concerned, no affidavit is filed. You also may grant me some time. I have filed that affidavit. As I find no letter was issued to the authorities in compliance of Lord's order January 2024.
2 weeks further time is allowed for the opposite parties to comply with this court's order dated 22/1/2024. No, this is on 2 weeks.
Item 13. Item number 13.
This was
Item 14.
With leave of your lordship, my lords, it's relating to allotment of a land under the Bhubaneswar jurisdiction for raising a 5-star hotel purpose. I have submitted before lordship a consolidated writ petition, and a counter has been filed on behalf of the state government GA department. I only need to place certain facts relating to GA department if your lordship gives me a week's time.
Hey.
As your lordship may fix it next week, next Thursday, I will give the documents.
What is your grievance?
Grievance is, my lords, there was a land allotted in my favor way back in 2008. And in 2009, I did apply for a hotel construction under the Tourism Development Department. So I am a unit which is backed up by certain promoters who are abroad. And in the meantime, I didn't construct because of certain lacuna and also laxities, as well as certain hindrances, because I didn't raise certain constructions due to want of my building plan being approved. And in the meantime, the building plan also got changed. Now, after the building plan got changed, before the building plan could get changed, there was a notice of revocation of the agreement that was signed in my favor. Then your lordship did protect me. In the meantime, when this matter was pending, the department, the GA department, wrote me a letter. You withdraw the writ petition and pay a certain amount of earnest money deposit. So we will allow you operate. Now, in 2021, my building plan got approved.
Now, I did pay the statutory fees as is being required by the nodal authorities who sanctioned my building plan. Now, the Bhubaneswar Municipal Corporation, they have also taken their charges, but to my discomfort, there is a fish vending zone erected by the Bhubaneswar Municipal Corporation in front of my frontage. It is existing as on today. Now, when this position was there, the GA department introduced a clause to the agreement which was not there initially to pay 15 crores as earnest money deposit. Then I suggested them the 15 crores at this stage, if I invest for earnest money deposit, my cash inflow will be there less, and I may not be able to raise my construction within 36 calendar months as has been stipulated. Then they reduced it to 40% of the IPR rate. At 1.25 crores per acre, it comes to 3.75 crores I have to pay as bank guarantee to them only to raise my construction, notwithstanding the fact that in the meantime, I have deposited 3.75 crores with them since 2009, apart from 48 lakhs to the Bhubaneswar Development Authorities and 37 lakhs to the Bhubaneswar Municipal Corporation for that 1% users fees. Now, my contention before the GA department was that may I be permitted with, I was under duress though, I will be paying 1 crore if I may arrange 1 crore of rupees to give a bank guarantee, because I am not a contractor. I am not coming under the OPWD Act. I am only a hotelier who is there, and I am to promote hotel business as well as I will be operating a business management school under the guidance of tourism department. So there, my only grievance is whether I should be given a waiver of that earnest money deposit, which has been introduced freshly during pendency of the writ petition, with a rider that you withdraw the writ petition. So this is my pith and substance, the grievance before Lordship, with relating to the GA department.
This writ petition, they want this writ petition to be withdrawn.
I have not withdrawn. This is the writ petition. This is the writ petition which they insist on withdrawal. Now the GA department has given a counter affidavit to my consolidated writ petition when I brought all these things into your Lordship's board by virtue of an amendment. Because all these things, all these developments, this occurred during pendency of your Lordship's writ petition on your board. So if your Lordships grant me a week's time, then I will bring certain informations, if at all it is required by your Lordships. Your Lordship can decide.
Who are you?
Yes, I filed my additional affidavit since that is a
2 months dated.
Yes. So there we have stated that in 2006, the valuation of the area land allotted was only 2 crores. Now it is more than 54 crores. Since 2006, he did not comply the order size per the agreement. And 2009, the agreement was revoked. And he subsequently in 2021, he got the plan approved by the BDA. And so that's why to ensure that he utilize the land for the purpose, we said that you to comply all these things, and we are ready to allow you to construct the building and hotel. And he's a hotelier, may invest so much of money, he cannot deposit 1 crore. I don't understand.
It is up to you.
Well, yes, it's up to me, obviously. But I am suggesting my only the counterpart.
You take a call. Take a call, we will decide.
Yes, I will only, I beg your Lordships only.
On behalf of the petitioner, list this matter on next Thursday.
Yes.
As the first case.
Because on request, they have reduced it.
Yes, that I am only suggesting, subject to your Lordship's approval.
No question of suggestion. Either resolve it outside the court or allow us to decide the court. Okay.
Like this, before your Lordships only, I can only beg, I can just press one of my prayers, because they are asking me 3 crores to be deposited with them idle. I am submitting that let me deposit some amount and let me the rest amount I will utilize on my hotel purpose.
What have you utilized the land for now? Have they got anything from the land?
No, we have not got anything because the fish vending zone is there. The fish vending zone is in front of me.
No,
as
it's facing the national highway.
You will get fresh fish from there. For your
if my Lordship, I am not at on your Lordship's.
When did you file your additional affidavit?
Because my additional affidavit was filed on
April.
Either you resolve it or take an order from the court.
Sorry?
I do get the message.
25/4/2024. 25 April.
Achi.
25/4, it is there probably. They have served it on the court itself.
Yes.
Item 15.
Your Lordship, till then my protection may be extended.
Is it continuing?
Till the next date, the protection granted to the petitioner by which order?
No, so I think
Order number
7/11/2021.
Yeah.
7/11?
2012 minutes. Status quo order was there.
So on Thursday, we will decide it.
No,
If there's a status quo order, you can't construct the hotel.
we can construct also. But we have made all other formalities because it will take 36 months. I tell you, Lordship, so it's a statement on, your Lordship can take it on record. We are not ready. Only thing is, if I tell the other word, your Lordship will not consider me. These are American-based company.
All right.
That is why they are ready with everything, but they want to spend the entire money on the hotel than to hold it there. That is the only advice. I'm grateful.
Item number 15.
Well, is the matter, I'm challenging the order of the Central Administrative Tribunal, my lord, that relevant page is 51, that the case of the petitioner, while he was in service, he was dismissed. Then thereafter, the tribunal allowed the original application and directed for a de novo inquiry. Against that order, my lord, the Kendriya Vidyalaya Sangathan before this honorable court, and that was pending till I have reinstated. So that period, the authority is directed as dies non. My submission before your lordship.
Which period?
That is from 1999 to 2008, my lord. They have treated it as dies non.
Why?
99, 2008, my lord.
Why?
Because that is this, they have treated it, that's why I am before your lordship. And they have treated it dies non, and stating that is the time they have consumed before this honorable court. They have filed the writ application against the order of the Central Administrative Tribunal. And by the last order, my lord, that this honorable court, they have paid me 2 lakhs something as subsistence allowance. Due to this dies non, my lord, my pension is less and I am not getting full pension, and this is I am entitled for subsistence allowance. And that suspension period, my lord, this is deemed suspension. When I have reinstated in service.
Deemed suspension under which provision? What?
My lord, 53.
So you were in custody?
FR and SR 53. OCCC rule also, my lord, that is.
You were in custody?
No, my lord.
Deemed
that I am deemed suspension because the original order, which was passed by the disciplinary authority, has been quashed by the competent court of law.
When was the order quashed?
My lord, that's why that is a deemed suspension on the date of reinstatement.
What is the date of the order or dismissal?
My lord, that date chart I have my lord, I have
compulsory retirement 4/10/1999.
My lord.
4/10/1999.
I have dismissed from service. And 2010, my lord, they have reinstated me.
11 years after that.
After that.
2000, forgetting one period. 2002 to 2007.
Yes.
You were a member of Jilla Parishad, so received.
That is when I was under the dismissal, my lord.
Right.
That is also I am getting honorarium. And the Learned Tribunal has not discussed a single word about that period.
2004. 29/4/2004, CAT allowed the 29/4/2004. Allowed OA 620 of 2020 and remitted the matter back for fresh inquiry. 31/10/2007. This petition 9371 of 2004 was filed by the Kendriya Vidyalaya in this court. No, sorry, it was dismissed by this court. This petition filed by it was dismissed by this court on 31/10/2007. That's the date. And he was reinstated on service on 14/3/2008. He was reinstated on service and placed under deemed suspension on 14/3/2008. And directed to pay suspension allowance for the period of deemed suspension. Order for payment of suspension allowance on 11/4/2008. 7/12/2009, suspension reviewed and continued. 29/3/2010.
So what is the period, what is the concerned period for which you have been denied?
Well,
That has been treated
from
to be-
99 to 2008,
Please give us the date.
my lord. That is from 4/10/99 to 33/2008.
1999 to
33 2008.
33.
30.
30 March, 30th March.
There is. 2003.
My
Eight, 2003.
2008, sorry. 99 to 30.
Where is the provision for diagram?
Well, there is, on my submission, there is no provision for dice.
There must be.
My lord, Rule 53, FR Rule 53, deemed suspension, and that is a government servant in whose case the order of suspension is deemed to have been continued in force, or who is deemed to have been placed under suspension from the date of original order of dismissal, removal, compulsory retirement from service under Rule 10(3) or 10.
Madam, the moment they referred to this expression dias non, that must be there in the service regulations. Your service regulation.
There is central government service regulation, my lord. That is no such punishment
No,
is.
whether in case of your Kendriya, you are an employee of Kendriya Vidyalaya Sangathan. Have you examined
My lord.
the regulations? Kendriya Vidyalaya Sangathan. Is there any different set of rules?
No, my lord.
Are you sure?
My lord.
What night is that?
Yes.
Well, that is an academic, my lord. Huh? What happened? My lord, see the prayer. Prayer of the writ petition. Prayer of the writ petition. Prayer. I will take my lord to the prayer of the writ petition. Prayer, my lord, as page 9 of the writ petition. On the circumstances stated above, it is therefore prayed that this honorable court may be graciously pleased to quash the impugned order 18/6/13 passed in OA number 178/2011 under Annex 1 and concurrently holding that same is bad, illegal and not assessable law. Thereby and direct the opposite party to release the substance allowance from the period from 4/10/99 to 33/99/28. Now we turn to the impugned order last paragraph. Page 52. 52 bottom. Page 52 minutes. Then the last operated part of the judgment. Order of the tribunal. I got it, minute.
Paragraph 10.
Paragraph 10, last to third line, 3 lines from top. The respondents have decided to treat the period in question as diazonon, and accordingly to Mr. Tripathi, when the period of absence is treated diazonon, official is not entitled to
Salary not to speak of subsistence allowance.
not allowance.
But NR Solanki.
Then, well, I am reading that. If the applicant is aggrieved by any manner, in any manner, he may first agitate the grievance against the said order, treating the period of diazonon instead of praying for payment of subsistence allowance. Then, for the discussion made above, we do not feel necessary to deal with any of these aspects of the argument advanced by learned counsel for the both sides, and accordingly the prayer is made misconceived, dismissed away. This is the order, my lord. Now, after this order of impugned order of the civil court, the petitioner files a separate OA before the tribunal, and that is a rejoinder she has filed rejoinder annexure 1 to 4, sorry, rejoinder. After the order of the tribunal, annexure 11. That was decided on my lord 2019. There in the tribunal, we filed in 2017. Input order of the tribunal is 2013. Now, after 4 years filed to tribunal, and on 19, tribunal holds that this is the order part of page 95 perhaps, if my page mark is correct, page 95. Para 20 minutes.
Yes.
Well, in the circumstances, we are of the view that the punishment imposed by the applicant while order dated 1910 is totally and shockingly disproportionate to the charges proved against him and stated in paragraph 50.2 of the OA, taking into account the fact that the applicant has retired from this meantime and the disciplinary proceedings are prolonged since 94-95. Instead of remitting the matter back to the disciplinary authority for reconsideration, we set aside the part of the order dated 1910 in which there are diagonal observations there. Annexure 4, treating the applicant period of suspension as diagonal and direct the respondent not to treat his period of suspension and deem suspension as qualifying service. But not is perhaps wrong for us, but I feel not is not there. Not is not maybe wrongly typed, not may place again. And direct the respondent not to treat the period of suspension and deemed suspension as the qualifying service for the purpose of pension and pensionary benefit. In the applicant, it is clarified that other aspects of the punishment imposed as per the order dated 1910 and are not affected by this order. The applicant is entitled to consequential differential pension and pensionary benefit of treating the suspension period as qualifying service and the area of differential pay and pensionary benefit as well as revised pension that will be sanctioned. This was to the respondent in 4 months. This order is filed with the rejoinder. After this order shown to the Honorable Court, this order pointed in the rejoinder, 1904 the order was passed. I see the 1904 order of this Honorable Court.
Just let him complete. Let him.
Because of the mistake, my lord, what my lord senior stated, because it is
No, not
for
mistake.
your lordship, that's why the tribunal didn't pass any order regarding that dies non
No.
not to treat the qualifying service because it is pending before this honorable court since 2013. It was passed in 2019.
That was
And this was the
second way.
this was the KV's lawyer's main submission that it was pending.
No. Please don't. Please not. Not.
Upon nothing.
Order 19 this order, we pointed out, this is not order 1904 order. 1904 order. Para 4 of that order. 1904 2024 order of this honorable court.
Where is that?
1924 order of this honorable court.
In this case?
Yeah, in this case.
Which order?
1904. 19th April.
Yes.
Para 4 may be seen. Senior counsel appearing for the opposite parties suggested that let the petitioner approve the authority concerned ventilating his grievance so far as the authority shall consider and pass approved order in compliance with the order of the passed by the tribunal. By the tribunal, means the which order I lost now, 19 order. But learned counsel for the petitioners contended that question of diagonal is to decide by this court. In view of the above, it is open for the petitioner to pursue the remedy before the approved authority in compliance of the order passed by this tribunal. In the event of the petitioner approach the authority by filing a petition within a period of 7 days from today, authority shall consider and pass approved order as expeditiously as possible. This is the order. Now, in the meantime, in compliance with this order, I just last date, my lord, I filed a memo in the order of you have to sanction the suspension allowance, and also pension has been granted already.
Everything has been
Already granted, my lord.
2 years out of 10 years of subsistence allowance, out of 10 years of subsistence, almost 10 years from 99 to 2008, they have paid me 2 lakhs rupees because of 2 years only. But that is my prayer before your lordship.
No,
Whether
that
I,
we are not chartered accountants.
Yes.
It will not compute.
my lord, whether
Just a minute. So you have treated
My lord.
that period to be
Yes, my lord.
in service,
Yes, my lord.
on duty.
On
No.
yes, my lord.
Where have you said?
I filed a memo to last doctor. The memo is there.
Treated a period as on duty but not paid anything.
No, no.
Not even subsistence
For
allowance.
pay substance, he is deemed suspension period. My lord, I will point out.
He's saying it has not been paid subsistence
He's
allowance.
saying that is not a grievance here, my lord.
There was some mistake. Paid the amount.
Yes, my lord.
Where
But
is
that is not impugned here. That 19 tribunal order of the tribunal 1990 subsequent order was not challenged here. Nonetheless, by virtue of my lord on 19 order, we have paid her this suspense allowance. She has received it already. If has any grievance, it was upon the tribunal. This is not the original court of
It is up to the
central tribunal. She will approach if you have any grievance over the quantum, etc., etc. She may approach the tribunal again, not here.
I'm
That was not to challenge here. 19 order is not challenge here. Tribunal said because there is a diagonal order, we are not going to suspend, not get. So it is going to judgment to Supreme Court. Judgment will be high. Now students say I don't go to any other points. She has come here.
So she challenged that order when tribunal said that you will not get.
No, no.
you have challenged.
Tribunal said because there is diagonal order, you are not challenged in that tribunal.
Oh, she has not challenged the Diaznon order,
No,
so we can't do anything.
Therefore, tribunal said go and first challenge the diagonal order. Taking advice of the tribunal, she files another way in 2017. Then gets order 19. As a mile until order 19 for order, you have paid that amount already. She has received that. Any grievance, further grievance.
Let us see where is your memo.
My lord,
I have given.
I have, my lord, my submission.
See, as we have understood, the only dispute is with respect to payment of your entitlement for the period 4/10/1999 to 33/2008.
Well,
So he is saying that that amount has been calculated and paid to you.
yes.
Let
Let him file an affidavit.
Already file an affidavit.
I have already given instruction to orders.
As per the direction of this honorable court.
Madam, see what have you done in the presented application? You have challenged an order passed by the tribunal.
My lord.
Now later you file another way.
That is challenging the final punishment. My lord, this is the order.
In that order, the tribunal has held that your Diaznon order is incorrect.
Yes.
You will be entitled for everything.
Not, my lord, not qualified service.
Not we can clarify. Not is not a difficult thing.
No, they have stated that from 2013, it was pending before the High Court. Then we are not entered to that area and I will pass the order. So I am getting only 7,000 pension. Because of this order, my lord.
All right. See, madam, the tribunal most unclear terms, most clear terms as held that period is not to be treated as that order has been interfered with.
Yes.
What problem do you have?
But they are not treating it because, my lord, because the subsistence allowance.
Not treating it, then he is right. You will have to go to the tribunal.
Because this order, my lord, because of this order, which is pending before this honorable court, this writ petition.
We will decide it today.
My lord.
Because of pendency of the writ petition, you cannot approach the tribunal and we can decide the dispose it of today itself.
My submission prayer before your lordship, let that deemed suspension period, the substance allowance may be released. That is the only submission.
Do you understand what are you doing in the present proceeding?
Yes, my lord.
What?
I am praying for my substance allowance to be released.
No. You are seeking, you cannot maintain this prayer. This direction you cannot seek. Because that direction you can seek in the tribunal. You are challenging an order of the tribunal.
Yes, my lord. Final order of the tribunal. That is, after my punishment imposed, disciplinary proceeding has been closed, and they have reverted me to major punishment imposed, increment, and I have challenged that because before in the final proceeding, my lord, suspension period will be
Madam,
decided.
finally, you started your submission
My lord.
with the only grievance that period has been treated as does not.
Yes, ma'am.
We are of the view that in view of the CAT's decision, that period is not to be treated as does not. Then why are you worried?
My
If
suspension.
you have any grievance, the court, he is absolutely correct in his submission that the court in the present proceeding cannot go into that.
2 lakhs rupees they have paid, my lord.
We cannot go into those aspects.
Because they are at fault because they have paid me 2 lakhs rupees as subsistence allowance. My only prayer before your lordship is that whether I am entitled for subsistence allowance, if subsistence allowance will be paid to me, then that dies not automatically goes because I am under suspension. They cannot say that it is break in service.
It's very difficult to convince you, madam, that they are not treating that does not order against you. That does not order is not there against you. If you have any grievance, you can
Yes, my
approach the
pension
tribunal.
is not been updated due to this.
I'm given already.
There, my lord senior is saying, my lord.
That is not a grievance here, my lord.
All right, you file your affidavit.
Well, I'll
File your affidavit.
I have filed a memo and given all the documents also.
It's this matter
Only
on
2
1 week.
years.
In the meanwhile, let an additional affidavit be filed on behalf of the Kendriya Vidyalaya Sangathan.
Well, with that, how much time I have now? How much time I have got to file?
1 week.
My lord?
1 week, 1 week.
Item 16.
Item 16, my lords. So far, writ appeal number 2393 and 2403. My lords, these two writ petitions of the limitation has not been condoned. Though other writ petitions, the limitations have been condoned. Perhaps this is the order.
2393, 2403.
My lords, these two left out.
What is the delay?
Delay, my lords, 272 days. That already my lords condoned on condition that we will pay 20,000 rupees, and it apportioned matters to be apportioned amongst the petitioners.
It's also 20,000.
No, who is for the other side?
Yes, my lord. My lord, I am appearing for the other side. My lord, in this case, though they have served the copies, we have instructions to appear. We will file our wakalat within a week, my lord.
Now, what should we? You file your wakalat first.
My lord, it may be contourned and the same order may
No,
be
but
passed.
unless you file your wakalat nama, we cannot pass order.
Yes, my lord. Okay.
All right, next week.
Grateful.
In the meanwhile, you do it.
Yes, my lord.
Item 17.
Appearing in VC, my lords. May I please your lordship, my lords.
Item number 17.
17. I am appearing in VC, my lords.
Yes, in VC.
My lords. My lord, this writ appeal is filed against the impugned judgment order dated 22nd April 24, my lord, passed by honorable single judge, in which, my lords, no opportunity has been given to these appellants, my lords. Lordship, lordship may kindly have a look to Annexure 2 at page 35, my lords. Annexure 2 at page 35, my lords. Lordship, on first day of hearing, honorable single judge issued notice to the appellants, my lords. No notice was sent from this honorable court, my lords. On the next day, judgment has been passed, my lords. Let's kindly have a look at page 35, my lords. Order dated 9/4/2021, my lords. Let's cut it, my lord. Page 35.
35 we have seen.
Yes. issue notice to the opposite party and the questions of admission by registered post with a D, speedy post with a D, fixing a short returnable date requisite for which shall be filed within 3 working days, my lords. Thereafter, the interim order, IA interim order is passed by. No notice has been sent from this honorable court, my lords, upon informations, my lords. No requisite has been filed by the petitioners there in the writ petition, so that notice has been issued, not issued. In the next date, my lords, the judgment has been passed without hearing. It's a gross violation of natural law.
Yes, so notice. Prima facie, we are satisfied that the impugn order dated 22/4/2024 has been passed by the learned single judge without service of notice upon the appellant. Stop. Accordingly, till further orders, there shall be stay of the order dated impugn order dated 22/4/2024 passed by the learned single judge in WPC number 12819 of 2021.
Much obliged.
Yes.
Much
obliged.
Item 18.
Item 18 might taken up on Monday.
Why?
Mr. Das is supposed to argue this matter on his legs in another court.
Not this one, the next one. As a request.
Item 19.
19. Last two matters I have problem to withdraw, my lord. I have filing memo.
First two.
First two.
Yes.
Manager, third one, I want to file the counter. 1 week time may be given. That was the last week. It was there due to my health and this holidays. I couldn't prepare the counter.
Third.
Next week.
Third. First two cases I am filing memo.
The fourth one is covered by your lordship order.
Just a minute. Third.
I want to file counter.
18832 of 2024. This matter on 1 week, so as to enable and counsel representing the DMEG to file counter affidavit. Fourth.
The fourth one is that is my matter, WPC number 19747, Miller. That is covered by your lordship order. Your lordship, based upon the judgment passed in Biswas case, Miller, dispose of an identical matter in which I am also appearing. That is Khordha. Miller, I have already brought to the notice of my learned senior, Mr. Mahanti. Because
My lord.
Yes.
My lord, this case, we will reconsider this case for renewal. We'll have to go for NOC.
In the 31st, your lordship last date picks up in Biswas case.
So you have filed a corrected order.
Corrected order with apology, Miller. Because your lordship order is sacrosanct, Miller, with apology. I have corrected it for the sake of convenience. Another order is also.
I know. But what is 7? Mr. Mahanti, the
Yes,
DPP has granted him NOC for the term 2022-23 on
23-24, my lord, the NOC was not given.
Not given,
but the cancellation was in June.
Okay.
Which deprived him for applying.
And this is a different order.
Yes, ma'am, this is different.
This is refused.
My lord, in each case, we didn't give him NOC, which was rejected in month of June. By the time the renewal time was over. So in this case, he couldn't apply for the NOC. So we may allow his case.
Allow him.
Yes, yes, ma'am.
I cannot claim.
Urgent copy because last date is 31st, Miller.
I will intimate.
2013 or 2024, we are the OP number 4 as per INC.
All right.
What it will be filed for?
Yes,
Sir,
you
them
look for
survey
respond
copy.
number, office report number 4.
Yes, my lord. The Indian Nursing Council OP number 4. 20132 of 2024.
All right.
But they didn't serve the copy.
I'm withdrawing that, my lords. The serial number 5, item 19, I have filed a memo of withdrawal. my lords.
Yes, we have seen.
No objection.
Item number 20.
My lord. My lords, I'm filing an additional affidavit. The lordships had wanted to know how the rates have been approved. I'm giving all the GST invoices by which, in accordance, the rates are approved by the hospital, my lords. Here, what has happened, my lords? I was a tenderer. My main grievance is I was a tenderer. If your lordship sees the annexure 2 at page 20. My lords, tender call notice for empanelment of medicine stores regarding supply of drugs, consumables, and other items to Bhima Bhoi Medical College and Hospital, Balangir. Now, that is at running page 20, my lords. This other items includes all orthopedic items. So, my lords, I had given all the indents which show that I've been supplying regularly till
But
date.
if we remember correctly,
Yes,
we
ma'am.
had asked you that you had said you had earlier been supplying.
Yes.
So we had probably asked you what are the items you have supplied.
Yes, my lords, that we have given, and medicine, and by the additional affidavit, we are also giving your lordships the price which it has been approved.
Find it in the registry.
Yes, first we'll file it in the registry. We have given copies to the state. We'll file it in the registry.
But the additional affidavit proposed to be filed on behalf of the petitioner be filed in the registry. This matter 1 week.
Item 21.
Yes,
Matter will come up next week.
along with the affidavit.
Obliged.
They filed.
Item 21.
Yes, my lord. My lord, here petitioner, a girl aged 20 years. A girl aged 20, admitted 20.
He is 20 years.
20 years.
He is 20 years.
Yes,
Then
ma'am. Admitted herself in the BTech degree. Not audible. Admitted herself in the BTech degree in the Synergy College of Engineering at Dhenkanal. My lord, after admission, she deposited the total course fee, but could not be able to prosecute because of illness of her father. The father became mental patient and continuously being treated at Bhubaneswar. Petitioner is also suffering from psoriasis and arthritis. My lord, the medical certificate is place 29 of his father. Became totally mental. And the doctor's certificate is placed at 33 and 34.
So you want return of original document?
My lord, thereafter I submitted that representation that I may be allowed NOC by the Synergy College. I may be allowed NOC to prosecute my study at Bhubaneswar because Bhubaneswar, the Gita Institute of Engineering, allowed me to deposit the less fee and to get admitted there. Because the heavy fees are 1,20,000. So I could not be because of my father. So after that, I approached the Synergy. Synergy denied that you deposit total 3 years course fee, then thereafter I shall issue the NOC. Thereafter, I approached every aspect I have approached, but they did not consider. But later on, I approached the my lords to direct them to return my original documents and to allow me NOC to prosecute my study at Bhubaneswar, my lord. In the morning, I approached the BPUT, since BPUT is the party, any council for the BPUT to serve a copy, but they denied that since the VC is denying the service of any copy, after notice is issued, they can receive that. That is the condition. But in the IA, I have filed a petition, my lord. The course, the back paper, I have some back paper. My back paper examination admission is fixed to 30 without fee. But after 30 to September 7th, it is with late fee. So I may kindly be directed to register myself. But the Synergy College denied. You cannot unless you deposit the total course fee, my lord. This is the fact, my
So
lord.
we cannot do anything without
Why did you come
waiting
so
for the
late?
notice.
No, my lord. I have approached, but the listing is the problem.
Listing is not a problem if you mention the urgency.
I mentioned, but my lord, that's what is the urgency that is. I mentioned.
We have never heard this.
No, my lord.
This
Yes.
type of mention.
What is the submission, my lord? The petition, the advocate, my lord, mentioned in the first one.
Huh?
One day, the advocate mentioned, my lord and friend. But my lord, that if there is no urgency, so that
My lord said that there is no urgency.
My lord, that may be separate. Submission may be different, my lord.
We can forget it, but how can we help?
We cannot pass any order without hearing.
My lord, I may kindly only think that notice may be issued.
I think Synergy, Mr. Palit appears.
My lord, I approached him also.
He said nothing.
Yes, he said that I am senior advocate. I cannot receive the notice unless notice comes, my lord. My lord, I may kindly be directed to register myself without late fee because tomorrow is the last date, my lord. Pending finalization of that aspect, I may kindly.
What is the late fees?
Let me 500 per paper.
How many papers?
3 papers. 3 papers. Pending finalization, my name may be
When
registered.
did you remove the defects?
My lord?
When did you remove the defects? Whether your petition was defect free?
Yes, it was once.
You filed it yesterday?
No, I have filed yesterday.
No?
Yes.
Okay. Oh, listing it was inside. You filed on 2nd August. What is the last date for registration with late fee?
Within 7 September.
3 weeks. We can't do anything. See, we don't know the nature of the agreement between the student and the management at Synergy.
Not pursuing the court, you want to ask for fees.
There may be some that you will be difficult.
If my lord pleases, I can take the notice, dosti, and serve there also. Matter.
Third.
Yes.
Item number 23.
My lord, the petitioner got the judgment in his favor. Thereafter, but the state went to Supreme Court. Supreme Court dismissed the initial contest. Thereafter, dismissed the appeal. Then, my lord, that order was passed on 15/4/2024. Thereafter, I repeatedly represented the government to make the payment. But there was a clear direction for making the payment of salary. And
Just
I got 23rd I filed an affidavit stating that the Department of Higher Education and asked the principal BJP or government college where she was working to give the details of the posting so that the financial implication has to be given and will pay it. That is the letter. I filed this affidavit on 23rd, Annexure A/1.
But the judgment is very clear. What period to what period salary will be paid. Judgment is by page 24. The lordship will be. The period is stated.
We worked in different places, not in one college. So that is why it was called for all that amount will be paid only after the financial implication is known. We don't deny that.
The 11th July lordship has directed them and 11th July.
Take up the matter on Monday.
Yeah.
All right. You tell us how much time will you take to implement the order. If
Yes,
you can't implement the order, then
No. It shall be implemented. Only financial implication so that we can disburse the amount. There no other difficulty is not there. No.
Is BJP college anybody opposite party? No.
No.
But you should have asked the BJP college.
Nobody required because BJP is under us. So we have asked the financial implication.
Within first 5 cases, so as to enable and counsel for and AGA representing the contemners to seek instructions as to within what time this court's order violation of which has been alleged in the present contempt application shall be fully complied with.
Yeah.
Item number 24.
Withdraw.
Item 25.
That matter regarding payment of TBA and SCP, it is the cost of the case is.
It has come for orders. Why?
Yes. He was appointed in industry department.
No, why not come for orders?
Because your lordship says that it will be dictated.
Oh.
After hearing your lordship.
It will come on Tuesday,
Yes,
Monday.
Yes, ma'am.
Item.
Wednesday.
Item 26.
Wednesday.
Item 26 matters. Item 26 matters. BDA is before matters. The BDA is the appellant. Municipal Development Authority is the appellant matters. There is a delay. I filed a petition for continuation of delay matters.
How much?
158 days.
158 days.
And you are appearing?
I'm appearing, my lord. Your lordship may kindly turn to page E of their date chat.
Yes.
Last clause 12. On 1/12/2023, the Honorable Single Bench was pleased to allow the repetition and directed to give appointment, and the order has been passed on 1/12/2023. Thereafter, on 12/12/2023, the petitioner submitted a copy of the order of the Honorable High Court. That is on 12/12/2023. Then on 4/5/2024, BDA received the copy of the order from the Honorable High Court from the registry and decided to prefer the present appointment. There is no explanation to the Miller delay. So this is my.
How much?
There is delay of 158 days.
How much money?
Money.
Cost.
10,000. All right, we are condoning the delay. Subject to payment of 10,000 to petitioner.
Within 2 weeks?
Within 3 weeks.
Within 3 weeks.
To the council for the respondent.
How about to the petitioner through the council?
My lord, one more thing. In this case, this is a case relating to rehabilitation assistance scheme, my lord, the appointment under rehabilitation assistance scheme. The father of the, my lord, this respondent died in the year 2010. And since then, I am my lord, moving before the court. So date may be fixed for finally.
4 weeks. 4 weeks. 4 weeks.
Pay the cost within 3 weeks, Mr. Mahabhadra.
Item 27.
Yes. Oh, prayer and the news.
Item 28.
Yes.
Mr. Samantra,
Well, the copy has been served.
Mr. Patnaik,
Yes,
item
yes.
28, do you have a copy?
No.
What is this?
No copy. My lord have taken so much of cognizance of a.
No, but they should serve a copy on you.
No, it has been, I think it has been registered also, no copies. Copies have not been, enforcement act.
This so moto. This court has taken so moto cognizance. Based on which the present public interest litigation has been registered. Yes, of a news item published in a local Odia daily, Samvad dated 18/8/2024, portraying the children of tender age crossing a river with teachers to attend their school in at Harda Goda under the
As for the noting itself, there is no legal. There is no legal in that today.
the condition as depicted in the news item prima facie amounts to violation of fundamental right under Article 21A of the Constitution of India. Let the records, let a copy of the records leading to registration of PIL be served upon the office of your Mr. Samantra and AG accepts notice on behalf of the estate. Let a copy of the documents leading to registration of the PIL be served upon him by Monday, by the registry.
I'll add some details after going through that newspaper article.
That the other day it was produced because also during the school minus matter. I understand.
List this matter on 3 weeks, 4 weeks. In the meanwhile, the court expects the opposite parties to file their affidavit.
Item 29.
Matter, I have filed the affidavit on 16/8/24. In reply, the noting is that no rejoinder has been filed, but I have filed. I have served a copy. Now that all the pleadings are complete, Lord's may fix it to next Thursday at 2 p.m. so that it can be disposed of. Already.
What is this matter about?
This is that land acquisition matter, my lord. I have filed the writ petition seeking that challenging the notification. And during pendency of the writ petition, a question was raised that since in a similar writ petition, the people were given an alternative land, I also prayed for that. Then because of a division bench judgment, that is not the correct law, and therefore they have filed a counter saying that alternate land cannot be given. When the matter was going on, then suddenly they have changed a stand by saying that government doesn't want to acquire the land, and therefore they want to denotify. And the process continued. And then I said that if you are denotifying it, give me back my land. Then this Honorable Court directed to conduct a survey and find out what is the position of my land now, because in their counter they have admitted that they have acquired the land, taken possession, and also given to different people. So if my portion of the land is still remaining, this Honorable Court said that you find out make a survey and find out and give it to me. So then they are coming up with a new stand saying that my purchase itself was not valid, because it is only after 4-1 notification I have purchased. But I have purchased before 6-1 notification. This is the sum and substance now relating to this. There are 4 matters. This is relating to one matter.
So this is an admitted position that after 4-1 notification you purchased.
Yes, after, because they have given the notification copy now. Now I am able to know that.
And the original tenant has taken the money, madam.
No, that is, I have disputed it, because
He has defrauded, that original tenant has defrauded the present petitioner. Also, they have defrauded the state.
Those things are right, but they are not acceptable, because my humble submission will be that out of the total land, only for a portion of the land he has taken the money. So it is yet to be known whether for the portion of the land sold to me, it was given. I have given in my rejoinder those things. They have not answered to that, but fact remains that he has not taken the money in respect of the total land acquired. Still some portion, only for a portion he has. Their own document. They have produced the document showing that my vendor has taken away the money. That shows in respect of a part of the land only. So they can't take a stand that
Part of the land sold to you.
part of the land acquired.
No.
I am concerned with the piece of plot where I have purchased.
Taken the money for the land which you had purchased.
No, that is what I am disputing. I am saying, but the document produced by them doesn't show that the total land money was given.
There is no question of total land. See, the value of the total land or the amount of compensation for the total land was say 5 lakhs, and 3 lakhs was spent. So whether that 3 lakh pertains to that land which was purchased by you or not, that is the question.
And your lordships are putting it the other way, but what I am trying to put it is that out of 70 acres of land, the vendor has taken money for 60 acres.
Oh, then you don't have any case.
That is what their
then you don't
document
have any
itself.
case. You will have to establish that your vendor
Has not taken the money.
Had not taken money in respect of the land which you purchased.
Yes. That much.
That you will have to. As jointly requested on behalf of the parties, place this matter on 2 weeks. Yes.
Item number 30.
Yeah, 2 weeks.
This is a case where the enema worker was regularized and then he was reverted back. It was challenged in administrative tribunal. It was rejected. For this, writ petition is filed. My lord, in flag C, kindly peruse. I have filed an IA for amendment of writ petition. 30.
These 2002 matters are.
What about the 29?
Is there any Supreme Court order in this case?
My lord.
Let us see. Where is the Supreme Court's order?
The Rao.
Petition.
Like X.
Yes.
My lord, I filed a IA for amendment of the petition because in Annexure 2, which by which the petitioner was allowed to work as a regular worker, was in the 4th batch, but in Annexure 2 it was wrongly mentioned 3rd batch in the order.
Wrongly mentioned?
Wrongly mentioned the 3rd batch order was given in Annexure 2, my lord. So
your IA is not there. IA number 12.
L 12, my lord. Flags.
After restoration, we will.
Yes. Have you served copy?
My lord, I filed it.
This can be done.
Yes, my lord.
IA number 12, 2024. This application has been filed seeking amendment in the writ petition. Oh. It has been stated in paragraph 3 of this application that out of inadvertence, office order number 6762 dated 30/12/1999 was brought on record by way of Annexure 2 instead of order number 6750 dated 13/12/1999. Stop. There is corresponding statement made in paragraph 5 of the writ petition. Oh. This can be allowed. What is your date of birth? Yes.
I filed an affidavit for that.
Separate affidavit you have filed?
My lord.
But that has nothing to do with this.
No.
No.
No, my lord.
He has filed an affidavit in Illustracy on 11/8/2024. There he has mentioned the date of birth is recorded at 29/1/67.
So when what you have mentioned in paragraph 3 that it was noticed means you have noticed.
My lord, is it transfer bill?
Stop considering the. There is corresponding statement in paragraph 5 of the writ petition with reference to Annexure 2. Full stop. Considering the facts and circumstances, this application is allowed in the interest of justice. Full stop. The petitioner is permitted to substitute order number 6762 dated 30/12/1999 in place of order number 6750 dated 13/12/1999 as annexure 2 to the writ petition. Full stop. In paragraph 5, let a consolidated petition be filed incorporating amendments in paragraph 5 of the writ petition as sought in the present interlocutory application.
Well, one problem may arise that if you may turn to annexure 2, that is the order number 6750 dated 30/12/1999. This order was cancelled at annexure 3. This is the subject matter of challenge. Now he wants to amend this and incorporate his appointment order. But let me see for a moment annexure 3. Page 21 of the writ petition. Unless both remain, well, also got it page 21. Annexure 3. You'll also see that the NMR personnel of the circle who had been provisionally appointed as wage Khalasi on ad hoc basis by this office order number 6750 dated 30/12/1999 is here.
Better you withdraw and file.
A better amendment application.
Amendment application. Huh?
And this was also filed in that writ petition, perhaps that has not been pointed out.
Very casual manner this application has been. Have you seen annexure 3? The annexure 2 was pointed out by us. You had not seen that. Right. For the petitioner seeks permission to withdraw IA number 12 of IA number 12 of 2004 with a liberty to file express application seeking amendment in the petition. As requested, list this matter on 4 weeks.
31.
Item 31, your lordship, in first matter, I am for the opposite party, and in second matter, I am for the petitioner. I have received the counter. I prefer 10 days time to file the reason.
When was the counter affidavit filed?
On behalf of Mr. Sarpati, he has also filed the counter, and in first case, he has filed his powers. Suddenly he feel ill and approached me to take the.
Current counsel appearing on behalf of the petitioner states that he has recently received a copy of the counter affidavit filed on behalf of the opposite parties. Full stop. As requested by him. List this matter on how much time?
10 days, your lordship.
2 weeks, so as to enable him to file, to consider the said counter affidavit and file reply if so required. Yes.
You're appearing in the second item.
In first item, I am for the respondent. Second item, I am for the petitioner.
Both items he is appearing. In one he is the petitioner, other he is the opposite party.
Counter affidavit in the second
Second
one.
item.
Second one.
Interim order may be continue in second item.
Okay.
Interim order is there?
Interim order of status quo by the order dated 19/7/2022.
So this matter is pending since 2005.
So one is 5 and the second one is 9.
No, as per my instructions.
And we are disposing of 2024 writ applications.
Situation.
One week. 2 weeks. 1 week after it.
That's on 32.
Giving you a short note, my lord. This is regarding the prisons. There are some reports relating to the first issue, if your lordship would like to take, is regarding that open air ashram. Open air prison. There's one open air prison, which is known as Biju Patnaik Open Air Ashram. It's almost about 15-20 kilometers from here. Here, if your lordship would see the report of the concerned DLSA, which is at page number 4 of that compilation we are giving today. This is all a part of your lordship's records. For convenience only, we have pulled out the relevant pages. Page number 4 at serial number 2. Conditions of jails and behavior of jail authority. That your lordship may see. There are some complaints regarding the concerned jail officers.
Yes.
So this is one issue which I would like to draw your lordship's attention. Then your lordship may see at page 5, serial number 4. Kitchen and food.
Yes.
That requires renovation, is what the concerned DLSA says. Then there are reports regarding wages of inmates. There, that is at serial number 10 of page 5. They have not been paid. Now,
where is that?
Page number 5, serial number 10. I'm sorry for paging it. I'm only highlighting the ones which are problematic. The good ones I'm skipping. And it's page 60, page number 6, serial number 16. This grievance is something which your lordship may see. This is coming again and again. This is the second time this report has come.
Present superintendent.
Present superintendent.
Allegation again.
He's making them do laborious work in heat, in scorching heat. And this open air jail, I'm told that this should be the model, almost a model jail where people should be happier. But these complaints are there. Then my lords may see regarding other interior jails, it would be at page number 10. On the last occasion, my lord wanted to know the scheme regarding these open air jails. That is there in the prison manual, rule 4842. Just for your lordship's reference, I just wanted, there's a scheme in the prison manual itself. Then so far as the other interior jails, there are complaints vis-a-vis hygiene at page number 10 of that compilation which I have given today. Page number 10, serial number 5. Hygiene of wards, kitchen, toilets, and washrooms.
G. Udayagiri.
G. Udayagiri. Another issue which is of some seriousness would be segregation. I have mentioned it in the note, all those jails. If your lordship sees page 11, there are two kinds of segregations. Segregations from UTPs and convicts, and segregation of young offenders from the elderly ones. There are repeated orders in this present case also. Serial number 8. At page 11. So this issue of segregation is coming up in various jails. In the opening pages, I have mentioned that.
Yeah.
Then another sub-jail, Baliguda, page 14. If I can quickly run through the issues there. Food is of substandard quality, serial number 4 at page 14. Then hygiene of kitchen is an issue at serial number 5 of page 14. Then segregation is an issue at page 15, serial number 8. If your lordships would see for convenience, in my note at page number, first page itself, under the heading serial number capital C, I have mentioned about the relevant rule in the prison rules, the order of this court dated 21/5/2022, and the jails where segregation is required. That is at page 2. Page 2 of the note, opening page 2. Under paragraph 3, the entire thing has been mentioned. Segregation of UTPs from convicts, there are 7 jails which have these issues. And segregation of young inmates from adults, there are 10 jails where these problems are there. Unhygienic conditions, 7 jails, I have listed them. This is based on the reports of all DLSs, which is at flag 179.
Yes.
So for the time being, these are the issues, if your lordships can take them up.
So we can take up this matter on Tuesday. We don't have time plus orders.
Can I request for a specific time if it's convenient to your lordship? Any time?
4 o'clock?
4 o'clock.
Tuesday?
Yes.
And in the meanwhile, have you shared this with him?
Yes, yes. All these.
I have got it now. I will.
Be ready.
Yes.
Point wise.
Yes, ma'am. We have also filed 3 affidavits, which is also related to this segregation of the young under trials.
No, your department is taking your steps, no doubt.
Yes, ma'am.
But so many things are yet to be done.
Yes, yes.
One issue will have to be addressed by the state, and that is the establishment of more and more open jails, at least one in each district. That is required. And unless you achieve that, your the purpose of open jail is not going to be served. So if you have one open jail in the state,
yes,
then that will not serve the purpose.
No, at least journal.
Not journal. district level.
District level.
And it is not very difficult. See, based on the conduct of the convicts for so many years, the jail authorities can take a decision to shift them to open jails. And what happens in open jails, they would stay in the night. In the day hours, they can go to their home to meet their family members home. And then they would come back. They may come back in the evening, stay in the open jails. So this is how you first of all, you watch the conduct of the convicts inside the jail, and then subsequent conducts while living in open jails. So that serves lot of purpose, social.
Pardon, my lord, in item 45.
There is one order of the Supreme Court which has come about recently, wherein they have interpreted section 479 of BNS to be retrospectively applicable. So once that is implemented, then most of these overcrowding and other issues. So the government, if they implement that quickly, then majority of these problems.
Is retrospective.
479 of the BNSS, that order Supreme Court has recently passed. So most of the problems would be resolved if this order is
In
implemented.
fact, again, Legal Services Authority will take aid of.
If your
Legal
lordship
Services
wants, I
Authority.
can give this order.
It is not required.
My lords, this has come recently.
479 is enough.
My lords.
My lord, I may be pardoned, my lord, in item 45.
Yes,
my
sir.
lord, item 45, it is a very urgent matter. Number of times the matter has been listed. May I pray for a Monday, my lord?
You always make this prayer at 4:30. What can make this prayer either in the morning or you could have said this.
I was not feeling well, my lord, morning.
Now you.
All right. So just remind us on Tuesday. All right.
My lord, deep look.
Item 44. One of the matters this is being very grateful. Grateful.